The Attorney General was suggesting that we
Yes, and
cancel the hearing of 502.
that would be preferable because, my lord, the reference by government is really for a new law to be enacted. That seems to be the memorandum of the government. So we don't know whether a new law will be enacted or not, so that the present reference about whether the bench of 3 judges on the one side is right or a bench of 3 judges on the other side is right, this idle. It'll only take up much of your lordship's time.
What we can do is we can defer the hearing of 502. Who's on the other side for 502? So maybe we can
504 both are together.
But what is the timeline? How long do you want us?
What I would suggest is, I think the committee should not take more than 2 months. And let me also try to expedite the proceedings of the committee. We'll give a report back to the committee, back to the court. As soon as the committee deliberations reach a conclusion as far as this particular issue is concerned, the manual lordship can take a decision on convening the court.
And the remit of the committee is to reconsider all the provisions of the Arbitration and Conciliation Act.
It's a very fairly large number of questions, but this question is incidentally also important.
It is not confined only to the issues.
No, there are other questions.
Other questions.
But I would request the committee to focus on this question as early as possible.
And what's the date on which the committee was constituted by the government?
20th June. 14th of June. 14th of June.
Mr. R. Venkatramani.
This finds a reference in an application. There's an office memorandum dated 14th of June 2023.
Mr. R. Venkatramani, Learned Attorney General for India, submits that on 14 June 2023, the Union government has constituted an expert committee with a broad remit to consider the provisions of the Arbitration and Conciliation Act 1996. Full stop. The Attorney General states that, submits that in view of the issues which have been raised in the reference to the Constitution bench would undoubtedly also come within the broad framework underlying the Constitution of the committee. Full stop. After the report of the committee, the government would take a considered view on the modification of the legislation is warranted.
What does 504 say?
Yes, we are saying 502 and 504.
504.
Mr. F.S. Nariman, Learned Senior Counsel, has also joined in making the same submission, as have the counsel appearing on behalf of the other parties. Stop. Hence, presently, we direct that the proceedings in the 2 references to the Constitution bench be deferred by a period of 2 months.
Your Lordship.
Full stop. The court shall be apprised on the next date of the progress which has been made following the constitution of the committee.
Fair enough.
So we'll list it, give a particular date. We are now in towards the middle of July, August, September. We can keep it sometime around the
End of September.
Can keep it on the 13th of September, which is a Wednesday, I think. 13th of September.
Yes, that's all right. Yes, certainly. Lordship, please.
Why is the committee to take into account the recommendation which we would give?
So there's needless.
The committee is bound to do that.
They're receiving
different issue.
large number of
That's a holistic consultation that will go on.
Yes, Mr. Banerjee says that. And this aspect can also be taken into account. And I hope you're also looking at the issue of the stamping of the arbitration agreement.
Yeah. What?
Stamping of the arbitration.
I see.
Court's power.
Who's sitting on his left?
Roy. This is, here is Narasimha Roy, then Narasimha, here is Roy. This is talking.
No, next.
Lordship.
One minute, just this. Item 501 has a batch of 17 matters relating to appointments in the judicial service.
Yes.
I appear for respondent 501.4 on behalf of Manipur High Court, my lord. Though I am the respondent, my lord, but then the questions which arises for your lordship's consideration before the constitution bench, I have formulated 6 questions circulated to your lordship and circulated to all my colleagues also, my lord. If your lordship so pleases, my lord, I can explain, my lord, because I have prepared a chart also of all the matters which are listed. They are coming from 6 different high courts. And Lord, what are the issues? I've just said one sentence.
Now tell us 1 second. Now we just take a roll call of who's appearing in which matter. 501, who's appearing?
Lordship, I am appearing for 501 as the lead matter. And Lordship, I am not from the judiciary, I am the clerical staff of High Court. Lordship, I am different from others.
Go, let's go one.
One by one, yes.
501.
Lordship, I am there. I am for the petitioner. And my matters are 501 and 501.9.
Chetan.
Lordship, now in this matter, we, in both the matters,
You're for the petitioner there?
Lordship.
I prepared a list
Oh.
of all these matters, Lordship.
And Lordship,
Mr. Hansari, you've got a list of who's appearing in all matters? Just,
Not who's appearing, but what, which.
okay, just give us that so we can write on that.
It deals with, my lord.
All right, excellent.
For example, my lord.
Just 1 second. Let's at least, so that we have, there are 17 matters. Okay, so 501.
501
Lordship,
is.
actually,
there are
I am
four
different.
matters.
1 second, ma'am.
We'll call you.
501 is Tej Prakash Pathak versus Rajasthan High Court.
This relates to, my lord, appointment of translators.
Translators in the High Court. Okay.
501.8, there are 4 matters from Rajasthan. It relates to National Talent Search Examination, granting scholarship to class 10 students. 501.9, appointment of translators, and 501.10, appointment of translators. So 501, 501.9, and 501.10 are same. You know. 501.8 is little different. Then second, Patna High Court, my lord, it relates to the same, my lord. 501.1 and 501.12, selection of district judges entry level in 2015-16.
Both same.
Then my lord, there are 3 matters of Guwahati High Court, selection of district judges entry level in 2011. Like same selection, 501.2, 501.3, 501.11. Then one matter from Manipur High Court in which I am appearing, 501.4. Selection of district entry level in 2015. Where my lord, there are judgments, my lord, where the difference of opinion between two honorable judges of this honorable court, detailed judgment. It was referred to, my lord, a larger bench, and then the three judges referred it to, my lord, a larger bench because of the pendency of this.
So it is in this that it arises, the reference order.
And reference is on the first matter, my lord.
This has no reference order.
Nitesh Prakash, Rajasthan.
Manipur has no reference order.
And 501.4, the two judges deferred. It went to three. Three said place it before 5.
Yes, my lord.
In view of the reference in
In
Tej
view of the
Prakash.
reference in the first matter.
There are two other issues which arise in the matter which I'll point out.
All
The
right.
petitioner.
All right.
Then 5 is, my lord, Kerala High Court. Again, my lord, relates to district judges selection in 2017. 4 matters, my lord, same selection. And the 5th is from Gujarat High Court, selection of post of district judge junior division in 2021 and 2022. 3 matters from there.
So except for 501.8, which deals with the National Council for Educational Research and Training, all other matters pertain to the high courts.
Please, your lordship.
I mean, high
Yes.
courts as the case may be the district judiciary.
Yes.
All right.
Yes.
Now you formulated now
I
just
have
to
not
have us.
If I may
Now
intervene,
tell us,
with
just one
permission.
second, don't talk out of turn.
Just a minute.
Now tell us now among the seniors who are appearing, just let's have an idea of who is appearing on this side and who is appearing on the other side. Who is appearing in support of the plea which the high courts are taking? We have Mr. Vijay Hansaria for the state of Manipur.
Manipur High Court.
Just one second, let's take that down.
High Court of Manipur, not state.
Sorry, yes.
Yes.
So we have Mr. Vijay Hansaria for the High Court of Manipur. Then who's appearing for the Rajasthan High Court? All right, Mr. Puneet Jain? Sunil Kumar Jain. For the Rajasthan High Court. Right. Okay, that we got. Now, who's appearing for the Patna High Court? Mr. Gaurav Agarwal.
It doesn't arise, it's the matter. If I leave it to the petitioners to ask, is that there's an application actually to detach this matter.
Oh, I see.
1.1, because this issue doesn't arise, but I leave
Yes,
it.
but that's an issue pertaining to evaluation process. This is not concerning to the matters which are listed here.
So we can then detach the Patna High Court matter?
Yes, but this issue of rule of change of rules of the game doesn't apply there, but subject to the petitioners arguing. They can
Is there any?
Mr. Sharma is in fact appearing in
501.1.
Who's appearing for the petitions in 501.12?
But according to me, the broad questions, then all the High Court assist your lordship. Because the issues
Fair
arise,
enough.
it will have an impact on.
Mr. Agarwal, are you ready? You are ready with the point also, right?
There's no material on the basis on which it has to be argued. I'm here.
No, on the principle, I
But this doesn't arise, so I don't know. I can address the lordship
to
generally.
assist us. That's what I was. So we will say that we are dealing, we will delink 501.1. What we will do is, we'll retain 501.1 and 501.12 on the board.
Please do.
All right? Because we also want to ensure that our counsel who assist us can sort of mark a docket at the end of the hearing. So,
Pleasure to assist.
so we'd like, all right. So, and then at the end, we will delink, go yaad rakhna, 501.1 and 501.12, we will delink. Now, so
My
we
lords,
got now the-
also
one second.
501.15, my lords, I
One
apologize to
second.
interrupt. I apologize.
Now, Guwahati, who's appearing for the High Court? Mr. Jose, right? Mr. Jose is 201. Mr. Jose, yes. Right. And then we are left with which High Court? Kerala.
Yes.
Kerala and Gujarat.
And Manipur.
My lords, for Gujarat High Court, I appear in 501.15. My lords, this is also a separate matter with the 2011 rules of the Gujarat Judicial Examination has been challenged. The rules of the game question is not an issue here, my lords.
Oh, 201 point?
501.15, my lords, which is Kirti Agarwal and others versus High Court of Gujarat.
Same in 501.16. Does this issue arise in one court? That arises.
My lords, in fact, in point 15, the same question with respect to the challenge to the rules is pending before another bench, my lords, in writ petition civil number 663 of 2021, my lords. So our matter may be tagged along with that and be heard along with that, my lords, because this question is similar to the question being decided therein.
What we will do is that we will just detag these matters. So 501.15, maybe we will detag them at the end.
Yes.
Because, after the arguments are heard, very briefly in 2 minutes, we look at all the matters and then decide what is to be detagged. Because for all we know that, something might, incidentally arise here. So,
Overlap quite a few.
May I come in for Manipur for half a minute?
just 1 second. So for Gujarat, we have Shraddha Deshmukh. Anybody else for the Gujarat High Court in these three matters? Shraddha, you are appearing for all the three matters?
My lords, I'm appearing for the petitioners in this case, not for the
Not
Gujarat.
for the High Courts. Petitioners,
Not
we
for the
just,
High
anybody who's for the Gujarat High Court? Dipanvita normally appears. All right. In Rajasthan, we have Sunil Kumar Jain and Pawan Shwetawal. So we have now the list of people who are arguing for the High Courts.
Manipur, I need to clarify something.
Yes.
Manipur, Malas, there is a difference of opinion.
Guwahati is
Page
close.
501.4.
Yes.
Whereas Manipur High Court, the slight difference in this matter is stage Prakash would be stage 2 if stage 1 is crossed, because the judges differed on all 3 points which were raised in the matter. This is Bhanumati as she then was held against us, against the petitioner. Justice Shivkirti Singh as he then was held in our favor in all 3 points. They differed on all 3 points. So stage 1 was whether they, by executive instructions, 309 rules could be overridden. That's the stage 1. If they cross that, then stage Prakash would come. The rules of the game is the second stage at that, and then procedural unfairness. On all 3 issues were raised before the court.
Therefore, we will have to decide the constitution. We'll keep this matter with us.
Yes, madam.
Because our decision on stage 2,
Yes.
you're right, it may not arise until stage 1 is crossed.
That's right.
But we'd like to have the assistance on
Very
stage
well, I'll
2.
be here. I'll be here on
And
that.
eventually we'll send it to the 2-judge bench. To hear the
3 judges because of the
3
difference of
judges.
opinion.
Yes, the 3-judge bench.
I just wanted to place it on record so that
Right.
it's not that we have to only argue Tej Prakash. We have
So that is a serial number.
that is 501.4. That's the one you
Go to the 3 judges.
Manipur.
The larger issue is of the full court reference recommendation, which did not amend the rules. I'll argue that also if the lordship were to.
All right. And Mr. Natraj, who are you appearing for?
Although in the matters with direct role in the particular issue, but the larger issue.
We will require your assistance on that. So you please be there so that, because this also affect you in other service matters. It just so happens that these are broadly only High Court matters except for one.
Apart from this was not it was challenged by the included in the final deciding the color. was granted by Rajasthan High Court. And the executive came to
That nothing apart from the English marks could be considered.
the that the English mark earlier was, but first time the committee has decided making that English qualified mark, considering overall impact of all of them. Are not.
Okay, that's our individual facts. We really need to address on the. Anyway, we're not looking at individual cases. We'll see the case. So now, what we can.
No.
All right. All right. All right. So what we'll do now is this. The lawyers who are appearing for the private parties in all these matters, please give us your appearances on a slip of paper. We just wanted to know, broadly, who's appearing for the High Court so that we have everybody present here to at least start the arguments. So now, we can hear Mr. Vijay Hansaria for the High Court.
Yes,
Mr. Nataraj, would you like to go first, or Mr. Hansaria will argue first so that you have some, because you don't have a live matter.
Our role might come only later.
All right, so we can hear Mr. Hansaria, then we can hear Mr. Who would like to go after that? Mr. Sunil Kumar Jain. Then we have Gaurav Agarwal, Jose, Sheshadri Naidu, and Deepandita. So 5
Would you
councillors.
like to hear the petitioners first, because
We can do that, no difficulty.
because they'll have to respond to the changes that they are supposed to have made in each High Court.
So what we can do is we can only request Mr. Hansaria, who has formulated the questions,
Yes.
to show us what his formulation is.
Very
We can share it with all of you. If somebody wants some little change, you can.
Someone here on this side. Who all will appear?
And for the petitioners, Haripriya, will you just take it upon yourself to tell us, Mr. Chidambaresh? Mr. Chidambaresh will be appearing for the petitioners in the Kerala matter. All right. Who are going to be appearing for the petitioners, and how long would you take? So we'll start then with the petitioners, because technically, you have to start first.
I've seen the questions, my lord.
No, whoever is wanting to appear on this.
Yeah.
Who's for the petitioners now, tell
Give
us.
us the details so that you will collate and then tell us.
Now for the petitioners, who will open the arguments?
Kerala Metro, I know. Because my item is 05 and 06, 501. Petition.
You are in 06 for the petitioners.
Because 5 and 6, there are batch of the matter. 5 and 6.
So Kerala for the petitioners, Dinesh, Haripriya, and Ragen Basant are going to be appearing. Mr. Chidambaresh also. All right, no problem. We'll hear you. Now, in the other cases, for Rajasthan, Patna, Guwahati, and Gujarat, who are for the petitioners?
But I'm for the Patna. Petitioner in Patna High Court matter.
So on the side of the petitioners, please give your not appearances, but just a small note to Ms. Haripriya Padmanabhan, so she can prepare it in a consolidated way and give it to us so that we can call out matters seriatim then.
I would
Statewide. Right.
Finish Kerala, then go to.
So on behalf of the state, on behalf of the petitioners, we'll go state-wise. All right. So we can perhaps do Kerala first. I think Kerala will be better because you have Chidambaresh, you have Dinesh, you have also.
I would rather have Manipur at the end, my lords, because
All
I have
right.
some additional points.
No problem, Mr.
Independent of those
Mukherjee.
6 questions, which I'll
Absolutely.
formulate and give it to you.
So
All
we'll
right.
do Kerala first.
We'll do Kerala.
So either in the beginning or in the end, because I'm the clerical staff and I'm different from others.
All right.
Tej Prakash. here.
We'll take up each set. So what we will do now is, first we will take up Kerala.
Look, I have formulated the question.
Just once again. So the order will be, we will first take up Kerala, then we will take up Rajasthan, then we can take up.
Subject to your lordship. What I was submitting is, my lord, the submissions.
Just 1 second.
Broadly,
We're just telling, we'll take up Kerala, Rajasthan, Patna, Then Guwahati. Then we can say tentatively Guwahati, Manipur and Gujarat and Manipur. Yes.
What?
Yes.
You can't be converting Assam, it's Guwahati High Court, it's not Assam High Court.
Yeah, it is Guwahati High Court.
May I point out one thing?
Mrs. Naidu will be available only in the afternoon. For appearing.
Petitioners are going to
Petitioners are
start.
starting. And Mr. Naidu is for the High Court, so he can come.
May I point out one thing?
Yes.
All this batch of matters,
Kerala, Rajasthan, Patna, Guwahati, Gujarat and Manipur.
in all these batch of matters, the situations are different from each high courts where they have interpreted.
Right.
So ultimately, the reference is also, bit vague, unless what exactly is the reference and how it is applicable.
Read the reference order.
Here.
We'll read the reference order by Justice Chalmeshwar's.
That will be possible.
Yes.
And the fact situations each.
Then
case-
we will have to see a little bit of the fact situation for all the states actually, because we can't just decide it in the abstract. All right. Yeah. Some of the broad. Sorry, now should we have a look at what you have prepared?
Yes, Lord.
And we can get started.
And finally, filed a for the written submissions on behalf of Manipur High Court. Writ petition 294 of 2021. Yes.
Let's see what is formulated. तारीख क्या 12 में? Next is 12.
Yes.
Yours is a 6-page folder?
Yes, 6-page note, my lord. Yes. And there is compilation of, my lord, the case laws which has been shared with all my colleagues also.
Just once. The 6-page note, yes.
My lord, sir. The following questions arise for consideration of this honorable court in the present set of matters. One, whether the selection of judges of the district judiciary and staff, and including staff because one of the matters related translators. Cut-off marks can be fixed for both written examination for viva voce examination, and a candidate to be included in the select list must secure the minimum qualifying marks for both written and viva. Because, my lord, one of the argument of the petitioner side is, my lord, the City Commission says there should be no minimum for viva, which, as per the argument, all India judges is accepted. We have a submission to make. That's one issue which arises. Whether the cutoff marks must mandatorily be fixed in the service rules or can be fixed by the executive order issued by the High Court. Whether in changing the cutoff mark after the selection process is started amounts to changing the rules of the game and is impermissible in law. Whether the selection is based, where the selection is based both on written and viva, what should be the proportion of marks to the main written examination and viva voce, and what should be the percentage of cutoff marks for the written examination for the viva voce. Whether the marks.
All these issues, do they arise in before the constitution bench?
They need not be.
Yes.
You may have
That's
collated it.
Manipur is separate, man. That's what I'm
That's
trying to
right.
impress.
Mr. Hansaria, you may have
So it's slightly
collated all,
separate
you
matters.
may have formulated it
Yes,
on the basis of issues arising in
The
these
case.
batch of matters
yes, my lord.
put together. But then the reference is on the basis of the judgment of Chalameshwar.
Yes,
He
but
refers.
Essentially,
see
the question, my lord, whether the rules of the game
These
can be
matters,
changed
for example,
after the
Manipur
rules
matter is also.
That is the reference.
Placed before the constitution bench.
We will see the, so therefore Manipur also will see.
Manipur,
Manipur where the
that's why I
three bench
reserve my
you
right
have
to
referred.
respond to this. These questions do not directly arise in Manipur, Tej Prakash will instantly there. So I'll have to make good. That's why I want to come in at the end.
So ideally,
I
I
want to come
think
in
what
at
we
the-
must do is we must look at the reference order.
Yes, absolutely.
And having looked at the reference order, then we will look at the individual state facts. You see, we'll take up each individual state and we are going to go, as I said, first
Two more questions, my lord. Can I
to
just
the
complete
Kerala
it?
High Court.
Then take your lordship to the reference order.
Yes.
Just two more questions, my lord,
Yes.
on the next page, page 2. Whether
Because
the-
we shouldn't be answering questions which really arise before a 2 or 3 judge bench, in that case.
That will be actually proper.
Yeah.
Broaden the scope of the reference also.
That's why
But can I come?
my submission in Manipur is Tej Prakash is not directly attracted to it. It comes as stage 2. So therefore, you have to cross the first threshold. And that is not before your lordships.
All right.
Maybe
What,
Let us read the reference question
Yes.
first,
I will just
so
show
that
from
we
the reference-
confine ourselves to what is to be answered.
Yes, my lord. I will
Because there could be peripheral issues in any of the cases.
Yes, that's, just two more questions and then I'll go straight away go to the Tej Prakash, reference. order.
you wanted to read the last 2 questions, right?
Yes, my lord. And then I'll take your lordship to the reference order, my lord. Whether the marks of the written examination should be published and or made available to the members of the interview board before awarding the marks in the viva. But 2 of your judgments says, my lord, that it should not be made available. That are 2 judgments of your lordship's court. Whether a candidate has an indefeasible right to be appointed if she has been considered for viva and or her name is included in the select list, and whether the High Court as an employer is bound to fill all the vacancies notified in the advertisement.
All right. Now we've got your point. Now, just 1 second, Mr. Hansaria.
Yes.
Now, what we'll do is we will take up Kerala first.
But-
Can we go straight now to Kerala for a moment? Who's going to open arguments for Kerala?
Hello.
Dinesh, you are opening arguments for Kerala.
Yes, my lords.
So we'll start with now.
Reference order in Kerala.
Yeah, let's go to the reference order for a second. In the
Sir Lakshmi, kindly
Mr. Dinesh, you are appearing. You'll be appearing in.
in 50105 and 06, my lords. But 05 and 06 are batch of matters. So in 06, other my learned friends are also appearing in 06.
So 501.5 and 6, right?
Yes, my lords. That is the lead case in Kerala matter, Shivananda.
The reference order is in 501.5 also in the paper book there?
Yes,
Or
ma'am.
do otherwise we have it in 501? We can read it anywhere.
Compilation of judgments and soft copies available with my lords filed by Mr. Ansari, my lords. I can refer to that, the soft copy. So everybody can refer to that soft copy, my lords.
You have filed the convenience compilation.
Yes, my
We
lords.
have filed
Mr.
4
Ans-
volumes, my lord.
Mr. Ansari has filed.
3 files, my lord.
So now,
Party matter, I filed first 3 by mistake.
and we've got the convenience compilation.
There are 4 volumes of 1, 2, 3.
Yes, my lords. In fact,
Dinesh, where is the reference order in your convenience compilation?
let me kindly see convenient compilation part 2. In fact, there are 3 convenient compilations Mr. Ansari has filed, and part 1, part 2, and part 3. I'm referring to part 2, serial numbers 13.
Convenience compilation 2,
Yes,
213.
yes.
Okay.
Serial number 13, Shivanandan CT versus State of Kerala. Short order, my lords. By Honorable Mr. Justice Kurian Joseph and Honorable Mr. Justice Panel.
PDF 260. Sivanandan, na?
Yes, ma'am. The convenient compilation 525 is the serial number. 2018 1 SEC 213.
मिला आपको? Just get it. Yeah. Pankaj bhai, मिला आपको? अच्छा, he will get it for you. You know, in Hansaria's compilation, if you click on Hansaria, you will get his convenient compilation 1, 2, 3. Huh? Hansaria's compilation. Yes, so that I got. In Hansaria's compilation, yes. Just click on Hansaria, then there is convenience compilation 1, 2, 61.
The running page of compilation is 526.
He's referring
Always
to compilation.
using PDF.
PDF
bus, it's better.
This PDF compilation, my lord.
Just
526.
go by
520.
PDF. Tell us PDF number.
T526.
Which para you want?
Please, my lord.
Para?
So, lords, this is a reference order, my lords. I have already submit, my lords. In fact, yes.
आप मित्तल सबको भी दे दो.
खुल गया है लेकिन. Yeah, sir, just go back. There are answers to our same compilation. Compilation 2 is okay.
Questions, have it?
I got it 259.
259. That is Sivanandan CT versus High Court of Kerala.
Before reading this, my lords, may make oral submission so that it will be easy, my lords. I'll just 3 minutes. I'll just tell you the facts, my lords, which led to this. Not the basic facts only for the necessary information. My lords, this is in respect of appointment to the post of district and sessions judge in Kerala.
Yes.
And we have a rule which covers the selection process, which is called Kerala State Higher Judicial Service Special Rules 1961.
Yes.
The selection process normally in Kerala, this is in respect of selection of 2015. We are concerned with selection of notification of 2015.
Yes.
Prior to 2015, all those selection process were as per the rules, took place as per the rules. And rule says that the selection will be, because there is a written examination and viva voce. Written examination, there are 2 papers, 150 marks each, and viva voce 50 marks, total 350 marks. Written examination, you have to score general candidates 50%, and exemptions are there for the reserved categories, like 40%. Then only you will be considered for the interview. And the selection will be as per the rule 2C Roman 3, my lords. The criteria for selection is the aggregate of written examination and viva voce will be taken together, and that marks will be the selection for the purpose of selectees. That is the final. And selection happened in the year 2014, same way. And 4 of my clients here, the petitioners in the first matter, there was no cutoff marks so far as interview was concerned as per the rule. 2014, the petitioners, 4 of the petitioners participated. They scored more than 50% in the interview, but aggregate they lost. So the selection committee said, sorry, you don't have aggregate marks. Though you have 50%, they were out. They were not selected. 2015, this selection, 2015 was the notification. Examination was conducted in the month of March 2016. February 2016, my lords. 17 it happened. Then I'm sorry, I'll correct my dates. The selection process, the examination was conducted in 2016. Thereafter, the results were declared in December 2016. Out of 400 candidates, 40 candidates scored more than 50%, qualified for the interview. So 40 candidates were declared and they were part of the select list, scoring more than 50% in the written examination. They were called for interview in the next year. An interview took place on 16/1/2017 to 24/1/2017. Yes, 17. Thereafter, my lords, after 8 days, administrative committee met. This is how the issue comes, my lords, here. Administrative committee met on 6th of February 2017. Then administrative committee took a decision that in the interview, the person should score more than 50% marks. That is, they fixed a cutoff mark after the interview took place, after the written examination, as well as the interview. The administrative committee met after a few days of the interview, because then took a decision saying that those candidates who have not scored more than 50% of the interview, so interview became the sole criteria. And thereafter, on 21st of March 2017, the full court met and gave approval to the administrative committee's decision. The selection committee was consisting of 5 senior-most judges of the Honorable High Court. And selection committee and administrative committee, the members are one and the same. They conducted the interview.
So your contention basically is that once the process had begun,
yes,
what they did was that after the interviews were held, they decided to have a cutoff of 50% marks in the interview, which according to you is impermissible.
Then, my lords, what happened? That is so the cliche has been used that rules can be, you can change the rules after the game is played. But in fact, my case would be
after the interview. This is actually after the interview.
This is after the interview. After the interview. And I'll just come to the other aspects, my lords. So my case may not be, the reference itself may not be recurred for the simple reason that it's a straightaway violation of an existing rule. So whether,
what does the rule say, you say?
Rule, my lords, 2C3
and which
of Kerala State Higher Judicial Services Special Rules 1961.
2C small 3.
Yes, my lords.
So rule 2C, what?
Small 3.
Yes.
What are the rules called?
My lords, Kerala State Higher Judicial Services Special Rules 1961. My lords, this is a rule under Article 233 read with 309, my lords.
Special rules.
Yes, my lord, special rules.
1960.
Because there is a separate special rule framed under Article 234, but this is a rule framed under Article 233 for the high judicial, subordinate judicial.
Rule contemplated taking only the aggregate marks into account.
Rule contemplates very specifically, and that was the practice also followed by the High Court, that the aggregate of written examination and the viva voce should be taken together, and that is the test result.
So your submission is straightforward, saying that the
So my
administrative decision,
yes, ma'am,
as well as the selection committee's decision is approved by the full court is contrary to the rule.
contrary to the rules.
So really speaking, the issue of
Doesn't arise,
the change in the rules of the game, etc., doesn't arise because
There is at all, my
the
lord.
rule itself says that you have to take the aggregate.
So my
You
responsibility,
can't do by an administrative notification what is contrary to the rules.
and all the judgments so far supported by Honorable High Court and this side, it very specifically says that Your Lordship have held that even 142 Your Lordship may not go against the specific rules, my lords. And we see Mr. and all those cases, my lords.
So Dinesh, was any attempt made to amend the rules thereafter?
In 2017, later on.
Perhaps-
Later on, they fixed 35%. Rule was amended
For the interview.
for the subsequent elections, for the interview.
And for this particular selection of 2015, the
No,
operative rule did not provide us a minimum cutoff
Cutoff
in the
marks.
interview.
Very
On
specifically.
the contrary, it says that the selection would be made on the basis of the aggregate marks which are obtained in both.
Exactly.
Now,
True,
talks about the litigation, what happened?
Litigation, I think. Then we straightaway approached this honorable court in 2017. in fact.
32 petition.
Yes, 32 petition matters, because there is a contrary. Because what really prompted us to approach this honorable court directly is that all those challenges were pending in the High Court. It happens after 5 years or 6 years. So instead, there is a direct contradiction to the rules, my lord. Straightaway we came.
So
to
you
this-
filed a writ petition before the Kerala High Court.
Came to this honorable court, in this honorable court.
32 petition.
32 petition.
Then
32 petition, notice was issued, and the arguments took place. And finally, there was, there is a reference order, the Tej Prakash was cited, saying that there is a change of rules after the game is played. In that case, as per the Tej Prakash reference order, this should be referred to along with the Tej Prakash case.
so you cited Tej Prakash.
No, my lords, High
The
Court
other
cited Tej Prakash.
All right.
Then we objected to it. And Tej Prakash is a case where there is no cutoff date at all for the interview. Cutoff marks at all.
Now
for the-
tell us one thing, just to argue on the other side,
Please, madam.
just sort of to elicit your response. The rule says that the selection will be made on the basis of the aggregate marks in the written and the viva.
Five hours.
The rule is silent about whether you must also obtain minimum marks in the interview.
Lords,
The rule, according to you,
Absolutely.
it tacitly also it tacitly excludes the possibility of fixing minimum marks in the interview.
Expressly.
Could it not be argued that, look, the rule is silent on what the minimum marks in the interview
In
should be?
that case, I would like to refer to the rule framed under Article 234, which talks about suitable person can be selected. So there is a question of suitability in 234 rules for the municipal magistrate selections matters. That suitability enables the High Court to fix some criteria. Here it is blank. So there is a, when you compare 233 rules and 234 rules matters, there is an express difference. There is a clarity there, and there is no power given to High Court under 233, even under the rules, my lords. There is a specific rule. That is a specific.
Question to you is,
Just explain.
Please, my
the
lords.
question to you is that the rule does not itself prohibit it.
Please, my lords.
So therefore, there must be perhaps you could interpret it to say that there is some amount of freedom for the High Court to modulate it and then ensure that somebody best can be picked up.
For the purpose of
Because
interpretation,
see, fixation of the minimum marks in the interview,
for getting the correct candidates, better
right, for
candidates.
getting better, is still consistent with the rule which says that the ultimate selection will be made on the basis of your aggregate marks in both.
Aggregate marks.
The only problem with this construction which I am suggesting is that it will lead to an exclusion. It will lead to exclusion of those candidates who would have made it on the basis of the aggregate marks only on the ground that they have not received the
That is-
minimum
that
marks
is
in the
precisely-
viva.
That is precisely my.
There will be a
submission.
clear conflict with the
That
rule.
is precisely my submission, my lords. 2014.
Because there will be several candidates, possibly,
Got in the written
who would have
form.
gotten on the basis of the aggregate marks. They may have got low marks in the interview, but that is more than offset by the high marks in the written.
Lords,
And they would be in that merit list, but they would be excluded because they get, say, less than 35% marks in the interview.
this in fact happened, 2014.
It happened.
Four of us, no other candidates, no other case. 2014, we 4 people appeared, scored more than 50% in the interview. But aggregate, I was not having, these 4 people were not having more aggregate. And when you compare the aggregate marks, they were down the list.
So
they were-
if they had applied this yardstick in the 2014 selection, probably you would have made it then. In 2014. But they don't apply the yardstick which they applied in
They followed the rules.
2014.
High Court followed the rules.
In 2014.
14. Then 2017, High Court amended the rules also. And here
Now
2017.
tell us one more thing.
Please, my lords.
What has happened in the meantime? People have been appointed.
My lords, there is an interim order by this honorable court where my lord is also party to, which says that it will be subject to selection, my lords. But those people got into service and they have been cut.
Dinesh, 6 years down the line,
Yes, my lords.
You have lost out on seniority for 6 years. Those people have already come in 6 years.
That is a fact, my lords. That's a fact, my lords, but
It's so important to deal with early. This place, people are working.
lords, there is
One of
To do this,
yes, my
we will go to your paper book. Look at the list of dates. You have given us the idea.
please, my lords.
What we will do is we'll see if the reference arises at all in your matter.
Please, my lords.
All right? And we'll see what to do. Come now, show it.
One more thing, the remaining matters which are there under the Kerala list that he has given,
Same.
all of them arise same issue.
Same selection.
There is no other Kerala issue.
No other Kerala.
Then okay, yeah.
Lords, one more.
Because
for-
Kerala is the selection of
Please,
2017.
my lords. My lords, before I finish, my lords, one more respectful submission, my lords. In fact, Kerala High Court filed a written.
1 second.
Counter.
Sorry, conception. Kerala, you go to 2017.
My lords. My lords,
Reference order of Justice Kurian Joseph and Justice Bhanumati, and then we'll go to your paper book.
please, my lords. Lords, may I kindly see the same page, my lords?
Small order, so it'll
Page
just take us
25.
3-4 minutes. Yes.
Lords, may I
You also
kindly-
give us the facts right away over here.
Yes, my lords.
IPM? All right. All right. Yes, Dinesh?
May I read that, my lords? Reference
Yeah.
order. Lords, para 3. May I read para 3? Para 3, my lords. As a matter of fact, two selections were.
Just read from para 1, actually. You might as well now.
Para 1, my lord.
1, yeah.
Please, my lords. The selection of district and sessions judges in Kerala Judicial Service in the year 2015 has given rise to this litigation. As per the notification dated 30/9/2015, the selection was to be conducted by written examination and viva voce. Written examination of 2 papers carried 300 marks, 150 marks each for the paper. Viva voce was for 50 marks. It was stipulated that those OBC candidates who secured 50% marks in written examination without any separate minimum and SC/ST who secured 40% were qualified to participate in the viva voce. In terms of the resolution of the full court, 13/2/2012, there should be no minimum cutoff marks for interview. The final merit list was to be prepared in the following manner. The merit list of successful candidates will be prepared on the basis of the total marks obtained in the written examination and viva voce. As para 3. As a matter of fact, 2 selections were held in the year 2013 and 14 without cutoff marks for viva voce. As for the resolution dated 13/12/2012, and after publishing the result of examination, the candidates were interviewed by the selection committee. However, after the viva voce, the administrative committee, consisting of the same members as the selection committee, resolved to draw up a list of successful candidates on the basis of the same separate minimum percentage of marks in the viva voce as in the written examination. According to the administrative committee, the fixing of minimum marks for viva voce was not a deviation from the approved scheme, since it was never the intention of the full court to select persons who do not attain the minimum required benchmark for such responsible post. The merit list thus drawn by the administrative committee on the basis of the minimum marks in the viva voce was approved by the full court, and those candidates were appointed accordingly. That selection is challenged in these cases. The main contention is that rules of the game could not have been changed after the game is played, and the result of the game is known to the selectors. Though the several other contentions are raised by both sides, we find that the decision in K. Manjushree versus State of AP squarely applies to the facts of this case. In Manjushree, 75 marks were allotted for written examination and 25 marks for interview. Aggregate governed the merit. However, the written examination was conducted for 100 marks. When the full court noticed this, a subcommittee was appointed to make arithmetical correction to scale down the marks in the written examination to 75 instead of 100. The subcommittee did two things. It made the arithmetical correction. Second, it introduced same cutoff percentage for the interview as in the written examination, and thus revised the merit list, which was approved by the full court. In the process, a few candidates were removed from the original merit list, including Manjushree. The bench of 3 judges of this court held that introduction of the requirement of minimum cutoff marks for interview after the entire selection process, consisting of written examination and interview, was completed would amount to changing the rules of the game after game was played, which is clearly impermissible. The bench specifically noted that resolution of the full court to not specifically stipulate minimum marks for viva voce was still in force. Yet, when the subcommittee introduced the change, the same was approved by full court. In Tej Prakash Pathak versus Rajasthan High Court has, however, specifically doubted the correctness of Manjushree on the point whether changing the rules of the game after the game was played is clearly impermissible, as made a reference to larger bench for authoritative pronouncement. It is also relevant in this context to note that Salam Samarjit Singh versus High Court of Manipur, which dealt with almost a similar issue, was heard by 3-judge bench in view of the difference of opinion, and it has also been posted along with Tej Prakash by order dated 10/8/2017. Hence, it is only appropriate to refer this matter also to the larger bench to be heard along with the Tej Prakash.
Now, the reference order does not notice a rule. It doesn't refer to Rule 2C3, which you have referred to in your submissions.
Did you appear, Dinesh? Did you not find out this
Specifically
point?
argued, Malik, the rule was the main contention.
Right.
Now, they refer to the aggregate. That is the rule.
That is the rule. In fact, they rely upon a
Full court resolution.
scheme of 2012. There was no cutoff date. My lords, the High Court counter, you'll also get correct picture when you go through the counter of the High Court, my lords. Very interesting counter. High Court, so far as interview mark is concerned, the contention of the High Court is that it's a fluctuating affair. On some date, the interview marks will be high. On some other date, interview, such a casual manner it has been prepared, my lord. Some date, interview marks will be less. And Shetty Commission report is there. There can't be any cutoff date which has been accepted by this honorable court for the purpose of selection, my lords. That is also argued, and High Court said there are certain other recommendations of Shetty Commission which was not accepted. So it is not correct to say that you have to accept Shetty Commission in toto. So we can take a decision. Then High Court also acknowledges that there is a rule, but for the purpose of getting better candidates, we are taking this measure. And High Court also, there is 5 categories for the purpose of interview. They have made 5 categories, normally for the grading for the purpose. And the merits and judging, they said this is the most important affair. So far as other cases like integrity, honesty, etc., that is the least important affair. So that we have given marks. So far as those people are concerned, judgment, we are not given those marks. But in fact, the written examination is nothing but assessing of skills of judgment.
Now, tell us only one more thing. Can we now look at the rules first? I think let's look at the rules which govern. That's the most crucial thing.
My paper book, Melos, it contains everything.
Yes.
Otherwise, there is a compilers.
1 second, we'll get it here.
We have your paper.
We've got your paper book. So you are appearing, Dinesh, in 501.5.
Yes,
You want us to take convenience or your written?
convenience compilation, my lords.
Of Mr. Ansaria?
No, Dinesh.
No, my lords, I have filed a convenience compilation, my lords. In fact, convenience compilation, I have filed separately.
Yeah. You've got your convenience compilation.
Yes, ma'am.
Milap. So,
50.
1.12. In there is a separate compilation.
That is at running 823, PDF 823 minutes. In the Shivananda's paper book.
It's in 501.5.
In the paper book, which is circulated to all of us, my lord, the registry is given us. So in the 501.5, the rules are there at page 834.
There is 823.
Oh, right.
First, may kindly see Shivananda's compilation circulated by the registry, my lords.
All right.
There the 823 index, it starts from index. Yes, PDF 826 in fact starts. Where the rules starts from rules.
Which page you want?
826. In fact, the index is at index begins at page 823. In Shivanandan's compilation.
Your convenience compilation is 139 pages.
Shivanandan, there is a separate convenient compilation which I filed in the Shivanandan's paper book, which running into more than 800 pages, my lords. Because there is a separate paper book.
Okay,
soft copy of
I
the paper
have the paper book separately. I'll take the compilation.
For Lordship, see page 834, PDF page 834, but you would get that.
You put it in the paper book again.
Convenience compilation, no?
Yes, convenience compilation, which I filed about
And
20 documents, my lords, 23.
right.
documents.
And which document are you referring to?
I start from the first, my lords, that you also can see the rules. Document number 1, my lords.
And that's the page I was saying, 834 PDF Lordship get, that's the same.
I have the convenience compilation.
Yes. The heading is convenient compilation note at page 838.
You want to refer to the rules, right?
Please, madam, I'll just take
That is the rules of 11th of July, 1961.
1961.
And it refers at the top, there's a handwritten endorsement, document number 1.
Document number 1. madam.
Got it?
Correct.
You got it. Ravi? ऊपर document number 1. That's it. Yeah, now only Pankaj right.
Submission by Dinesh. We are seeing that.
Yes.
First document number 1, my lords.
Just 1 second, my learned brother. Just निकल के इसके. इसको final है. Problem is. Threshold और समाधान. Problem. Saying look at the what we have given. And so then go there. Oh, it could have running volumes available. I made that. Okay.
Yes, if you can.
Yeah. Yes.
Please, my lords.
Rule.
My lords, you may kindly see the rule in exercise of powers under 233 and provides to Article 309. The rule framed under, my lords.
Yes.
Just below the notification. Now, my lords, the rules, there are 3 modes of selection, my lords. We are concerned with category number 3. Entry level, my lords. And the category number 3, 25% in loss. 25% is earmark, which your lordship may kindly see 828 or internal page 3, my lords.
No, it is, let's go to 2C, method of appointment.
Yes, my lords. 2C.
Appointment to categories 3 shall be made as follows.
Yes, my lords. 50% of the posts in the category shall be filled up by the appointment by transfer from category number 1. And merit further, my lords.
Yes.
25% of the category shall be filled up by the appointment by transfer based on limited competitive examination and viva voce and on the basis of merit and ability from category number.
We are not concerned with that.
We are not concerned with that. And let me kindly come to
3.
25% of posts in the category shall be filled up by direct recruitment from the bar on the basis of aggregate marks grade obtained in a competitive examination and viva voce conducted by the High Court. This is the rule.
What this rule seems to suggest is that you have to aggregate, you have to accumulate both together, and then that's the final panel.
Please, my lord.
You see, there could also be a situation of, we have the rules here, and in the Kerala case, of course, there was no departure from the rules. But then suppose on an overall look at things, even if you come in the select list on the basis of the aggregate, you don't have an indivisible right of appointment, right? That is understood. So in that case, suppose they fix a cutoff in order to get the best people in the perception of the selecting authority. Can you say that that should not be permitted?
But it should not be prejudicial to my rights, or there should be interstate discrimination among the persons who are appearing for the examination.
In what way you are saying there is interstate discrimination?
Because fixing a cutoff date, like
You mean to say that somebody who has scored lower in the written marks,
True, my lords.
and you have scored higher, you will sort of lose out because the other person has got the above the cutoff in the viva.
Viva. Because viva, why the Shetty Commission said viva, we can't mistrust, we can't question 5 honorable judges, my lords, and their wisdom. But there are inherent problems with viva laws. There are a lot of tests also. I can take my lords to the test on bias, my lords, and I saw certain literature.
But here we proceed on the basis that the viva is a valid method, and because the marks for the viva are only 25, right?
25.
So we proceed
50% of the total marks of viva. In
But
2017,
there's no challenge to the marks allocated for the viva over here.
50 marks.
How much?
50 marks and 25 is the cutoff. So you have to secure 50%.
Actually, you can phrase your argument in this way. Suppose you prepare 2 lists. One list consisting of the aggregate marks which you have obtained in the viva and the written examination together, cumulative, aggregate them and prepare a list which will give you an order of merit. Second list, for comparison, prepare a list of persons who get at least minimum cutoff marks in the interview, plus the marks which are obtained in the written examination, and prepare a merit list. Many people who are in the first list may not be in the second list, because though they were high enough in the order of merit to warrant selection in the first list, by virtue of the fact that they didn't get 50% marks in the interview, they would be out of the second list.
But there can be a situation, my
Are there such people before us
lords,
who
there
got
are-
excluded?
lords, may kindly say,
Okay.
There is a case
There-
where
it's all
a
right.
person can, in interview, 25 marks he should score. The person is getting only 24. And he has got high on the merit list, written examination. He's also out. So here a situation where interview becomes the sole criteria to judge. And we have to see how the High Court dealt with the situation. Suppose,
Now tell us, where did we get this thing about how many marks for the written exam, how many marks for the interview?
my lords, there it is in the advertisement notification. Notification was in.
Where is that notification?
I
over
just
here?
come to the notification, my lords.
No,
I-
in this compilation,
This
Dinesh,
compilation.
In the compilation itself, it is there, my lords. Lords, may kindly see the notification.
22 page.
D4, document number 4, my lords. And
Let's go to that.
now D6, my lords. The D4 is 2014 notification.
Yeah, 37.
And 8 document number.
That is PDF page 871.
39, 2015 notification?
This is 39, 2015 notification.
Page.
Now, let me kindly come to internal page 39. That black letters, my lords, 39 on the right hand side. Black numbers, man. Lordship,
6.
39, right?
yes, my lords. Let me kindly see 39, that paragraph, my lords. Just above that, mode of selection. That is 38, my lords. May I read 38, my lords?
Yes.
Mode of selection.
Just a minute. My brother is. But while we are getting at the page, my brother is getting at the page. Why did the Kerala High Court say in their affidavit that marks could vary on a day-to-day basis?
No basis.
No, because what I understood, because I was also there in Kerala. So by virtue of my experience, I know that there's only one interview board, because sometimes there could be a very large number of candidates. So you may have multiple interviewing boards. So there could be, difference in marking.
True, my.
Perhaps they were referring to the refreshment that is served to the interviewing members, because sometimes very often you say, "Oh, what a wonderful
My lords, there are
set of
interesting
refreshments."
studies on bias, my lords. Even bias tests on judges also, my lords, in the US conducted. And many tests, most of the judges failed, my lords, in bias tests, my lords. Implicit bias, in fact.
Yeah, we are now ready.
Please.
Yes.
That's what makes us human. Yeah, many a times. Yes, Dinesh?
Please, my lords. 38, my lords, mode of selection. Selection shall be on the basis of a competitive examination consisting of a written examination and viva voce. The competitive examination will be common for the candidates who apply in response to the notification. There are different notifications, my lord, for the reserved candidates also. Come to the last two paragraphs. My lords, may come to. The total mark for written examination is 3 examinations given below. The prescribed duration of each paper will be 3 hours. The general candidates and candidates belong to other backward classes who secure 50% and SC/ST candidates who secure 40% aggregate minimum for both papers together shall be declared as qualified for viva voce. Maximum marks for viva voce shall be 50. The merit lists of successful candidates will be prepared on the basis of the total marks obtained in the written examination and viva voce. If the number of applicants is disproportionately large vis-a-vis the number of posts to be filled up, the High Court reserves the right to shortlist the candidates by their length of practice at the bar, and such shortlisted candidates alone will be called for the written examination. However, such shortlisting will not be applicable to the candidates belong to the scheduled caste and scheduled tribes. The schedule of written examination will be announced later.
So even in the notification of 30th September 2015, they say aggregate marks.
Aggregate marks.
And the viva.
So,
and in the viva, you must get, the total are 50 marks for the viva. So 300 here and 50 for the viva.
True, my lords. May I kindly see the counter of the response of the High Court will be here.
Left in the rules for the High Court to
September 2015 also says aggregate marks. Now, when did this requirement of a minimum cutoff come in Kerala? For this, for this,
Yes, ma'am.
when did that come in? Show us that
This requirement, Your Honor, kindly see the decision of Administrative Committee.
page. Which
86.
document?
The same document, my lords. Page, the black numbers, my lords, 86.
Document number?
Same doc, I'm sorry, my lords, counter affidavit of the High Court.
That document 15.
Document number 15, my lords.
You got the counter affidavit, brother. You got it.
Yes, ma'am.
Thing is, in the
Look,
same
this is how
compilation,
the-
86, it's then
Page 86, my lords.
67 of this compilation. 67.
The basis of the decision.
Yeah,
Page
quote-
86,
quoted.
that is page 920.
In here,
Some variation to 912.
67, and you can go to 86, page 86. Pankaj, go to page 86.
starts at 67. Almost 2 years after that, huh?
2 years.
Selection process took
After
2 years.
67.
87, 86. 86.
And all selections in Kerala, my lords, were under challenge. And it's been under. Let me kindly see page 86, my lords, how the decision was taken for the first one. May I read the decision of Administrative Committee, my lords? The
Para
Administrative
22. Para 22.
Para 22. The Administrative Committee, which met on 27/2/2017, resolved as follows. The Administrative Committee considered the marks secured by the candidates in Viva Voce examination. Though in the scheme approved by the full court on 13/12/2012, it is stipulated that there shall be no cutoff marks for the Viva Voce. It is not an empty formality. The Viva Voce is expected to be conducted in a thorough scientific manner. Each candidate has to be interviewed for 25 to 30 minutes. 6 different heads under which the marks are to be awarded, and maximum marks that can be awarded under these heads are also stipulated. So it is clear that certain minimum standards are expected from the candidates without which they cannot be found suitable for the post. The Administrative Committee meticulously examined the marks awarded to each candidate in Viva Voce by the members of the selection committee under the above 6 different heads. After such, I'll just show you the heads, my lords. After such examination, the committee is satisfied that prime consideration of the selection committee, which awarding the marks in Viva Voce, was the suitability of the candidates to man the notified post. It is the ultimate object of the Viva Voce to weed out incompetent and unsuitable persons who may skews into the survey by mugging up answers in the written examination. The catena of decisions of the apex court also lays down the above principle. So the committee is of the firm view that stipulation of 50% and 40% marks, respectively, for general and SC/ST candidates in clause 5 of the notification, in the present selection and similar clauses in the other notifications for which common examination was conducted, is essentially applicable to the Viva Voce examination also. Only such candidates who satisfy such above parameters alone should be qualified to included in the select list. On the anxious consideration of the scheme, the committee finds that above view cannot be considered as a deviation from the approved scheme, since it was never the intention of the full court to select persons who do not attain the minimum required benchmarks for such irresponsible post. The split up of marks under the 6 different categories will indicate that 30 out of the total 50 marks is for the first 2 categories, which are of paramount importance of judicial officer in the cadre of district judge. The candidates who had obtained less than 50% marks in the Viva Voce had fared very badly in the above 2 categories, and whatever little marks they had obtained are mainly under the remaining 4 less important heads. That's not, I'll also show you the heads, my lords. And therefore, the committee is of the firm view that they are not suitable to man the post to which the recruitment is carried out. Recruiting such persons will be disservice to the public at large, which was not the intention of the full court. So the final merit and select lists are to be prepared in such a manner that only general candidates and candidates belong to other backward community who are obtained 50% marks and above, and SC/ST candidates who have secured 40% marks above in the Viva Voce are selected. Now, Your Honor, kindly see.
Now, Mr. Dinesh.
Yes, my lords.
One point in your favor and one point against you. I'll put you both. Point in your favor is that the committee does not refer to Rule 2C at all, right? It seems to have missed that Rule C had provided for aggregate marks in both. That's in your favor. 1 point against you. If you are right, then there could not have been the fixation of minimum marks in the written also.
Written action, written marks, my lord.
See, the fixation of the minimum marks in the written exam didn't come under Rule 2C. It came under the notification of 30th September 2015.
Please, I have an answer to this, my lords.
Now, therefore, otherwise, technically, if you are right, you can't fix even the High Court could not have fixed a minimum mark even for the written exam. Because the rule was silent. Rule said just aggregate both and draw up a merit list.
My lords.
Yeah, the best of the lot would have been selected.
My respectful submission is this, my lords. There are SETI Commission considered this issue and suggested that
We're not going to Shetty right now. We are on this point here. We are now whether it's ultra vires.
Yes. So far as merit is concerned, my lords.
So once we accept that the fixation of a minimum mark for the written in the notification of the High Court, which is an administrative notification, is valid,
How can it be wrong?
then how can it be wrong for the Viva?
But Your Honor, kindly see how the High Court understood this, page 91. Then I'll answer this, my lords. Kindly see page 91.
Now there also there may be an answer,
Yes, my lords.
which is that the fixation of the minimum marks for the written, which took place on 30th September 2015, was before the commencement of the selection process. Was it before the advertisement? When was the advertisement issued?
2015.
Advertisement was issued when?
Notification, my lords. 2015.
13 and 15.
2015, my lords.
30th September 2015 or that same advertisement, is it?
Yes, my lords. 30th September 2015.
Oh, so simultaneously they said you'll have to have minimum marks in the written exam.
Yes. Thereafter, this administrative committee decision was much later,
It was much later.
after the Viva was said.
They participated.
And also that's not wrong.
They participated.
Respect to the written examination part of it, we are prescribing the minimum.
Notification, my lords.
That written, that minimum marks for the written.
Yes, madam. I'm just waiting for
marks for the interview for the Viva.
D6, my lords. D6, document number 6.
By the time the administrative committee takes the decision on 27 February 2017, the Viva is already complete, right?
Pretty complete. Viva was in January.
That's the way it's.
Viva was in January,
Egregious because it's a
16 to 24.
That's creating, that's even egregious.
Yes, ma'am.
The notification was issued, when the written was held, when the Viva was held. So the-
Before that, Your Honor, kindly see page 91 for a moment.
अब इतना ही है.
Please, my lords.
Were you in the selection committee at that time or no?
Absolutely. There's a lot of meaning there, my lords. Very lot of words. Your Honor, kindly see page 91.
Chidambaresh, what happens is, when the High Court, we've all been, except Brother Narasimha, we've been High Court judges. When you sit in the selection committee, you're looking at the best interest of the institution. The motive is very, very laudable. Question is whether it is lawful. Sometimes what happens is, the High Court judges, you really feel that, look, this is the crop which we are taking into the judiciary. That's what weighs with the.
The cream is to be selected, no doubt, but not after the event. They had the tabulated marks before them. They wanted to exclude one, include another. See the favored candidates. They got low marks in the written examination, jacked up by Viva OC. I'm not attributing any malefactors. See the language used by the full court.
You're going for interview now? This is the method.
Can I bring to your lordship's notice the scheme of the examination, Lord, which is very relevant. The scheme of the examination.
kindly allow me to show only 2 pages.
Two more pages, all right.
Question, can you see page 84?
Page 80.
84, same, Mellows, the para number 18. Just point out the breaking of Mellows, how it happened.
Same.
Yes, ma'am. Page 84, Mellows. Knowledge and comprehension, this is part of the counter. 10. Skills for judging, 20. High Court says these are the 2 important aspects.
These are the two.
Other lesser important aspects. Ethics and attitude, general knowledge, question abilities, and character. In fact, Mellows, the interview should have been for these 4 elements, not the first 2. First 2 covers the written examination. Covered by written examination.
No, no, it's
Not
not like that.
necessary.
But then, even in the interviews, we have all attended interviews. You actually have questions on a lot of substantive issues. I can tell you that as judges of the High Court, when we sat on these interview panels, Mr. Chidambaresh will also bear us out. Actually, I used to prepare a question bank of 180, 200 questions because you would be sitting for 5 days, 6 days, 7 days, after work, sometimes during work days also, but usually after court hours. So the questions which you pose are also in substance, because if this person just mugging up, as a committee says, is he just mugging up the questions, the answers?
With great respect, Mellows,
Or sometimes you throw a practical question on, say, res judicata. Not what do you mean by res judicata, but will res judicata apply in this factual situation?
My respectful submission, my lords, so far as this merits of the person is concerned. Suppose a question is put to a person about the constitutional morality. Then some people may say, for example, of this honorable.
The questions by and large are not subjective questions. The questions which are put, say, even at the direct recruitment of district judges, they are all on the nitty-gritties of the craft.
I'll just
CRPC.
come to page 90.
You asked Mr. Chima. Mr. Chima is also sitting there. He rose from the district judiciary, became registrar general, secretary general here, and then a high court judge. NCLT. So these people have seen the district judiciary over a long period, much longer than us also.
But you can only see page 27, para 27, page 91. Marks awarded to a candidate in Viva Bose depends on her performance on a given day. So a candidate who secured higher marks in the previous election need not be
87.
27.
90. Scroll down. Oh, page 91. Yeah.
Lacking, my lords. 91.
That's okay. Some affidavit is saying. The affidavit,
it's affidavit, my lord, the High Court, man. Marks awarded to a candidate in Viva Bose depends on.
Oh, that's okay. There's neither here nor there.
not a.
I'm not reading.
Yes. That's my question here.
So, my respectful submission, my lords, I can take my lords to the judgments also, how the Tej Prakash is not applicable, how the Ved Prakash Marwa, because Tej Prakash is a case, I just already submitted, my lords, Tej Prakash what it is, how the Tej Prakash came into. Tej Prakash was an issue of selection of English to Hindi translator and Hindi to English translator. Then there was no cutoff marks. After the interview, the Chief Justice suggested, for the High Court only, Chief Justice suggested that there should be 70, those people who have scored 75, the best, should be selected. And those people who are left out, there were 13 vacancies, and three were selected. So those people who were unselected, they filed a petition saying that initially, this 70, it was from 55 to 75, that 55 is not available, but because this is after the game is played. Then, the Honorable Court referred to Manchester. And before that, this Honorable Court also held that 309 rules can be retrospective as well as prospective. Thereafter, this Honorable Court proceeded on the basis that Ved Prakash Marwa, that is of Subhash Chandra Marwa, of 1974 judgment, that was not
referred to in Manjushri.
In Manjushri. But Ved Prakash Subhash Chandra Marwa is a case where the marks were raised from 45 to 55.
Oh, I see.
So there is no vested right.
Dinesh, what we'll do is, now you just give us the 3 or 4 relevant dates in this 2017 selection batch of cases. since you are ready to the hilt, we'd like to hear you briefly on these judgments also, because we may or may not have to address that in your issue, but we'll have some other matters that we may have to go to the constitutional issue also before the CB. So we'll hear you on that also, because you are ready with your fact. But just give us the relevant dates in this 2017 selection. The dates are common in all the matters, right? And
Yes.
Just give us the dates, that's all.
Just give us
I
the.
will briefly state the
Just give us the dates.
Just give us the dates, so that 17th selection.
The Kerala State Higher Judicial Service Rules 1961 came into force on 11/7/1961. The scheme of the examination is notified on 13/12/2012. The relevant parts of which have not been read over to your lordships till date, which is an eye-opener. I have got 4 points. I have got. I will come to that after the dates are.
Just start, give us the dates.
Yes. Then this notification comes on 30/9/2015.
The scheme of examination is a part of the rule.
The scheme of examination is an administrative notification or it's a part of the rule?
It's an administrative full court.
It's a
based
full
on
court.
the
It's a full court resolution, I think.
Minutes.
We'll just go to that. That is, we have not seen that yet.
Exactly.
Now, 30th September 2015 is a High Court notification.
The written test was conducted on 12/3/2016 and 13/3/2016. The notification regarding candidates qualified in the written test came out on 17/12/2016. The Viva OC was conducted from 16/1/2016.
17.
17.
17. To 24.
17 to
24,
120.
The minutes of the administrative committee is dated 27/2/2017. Which was approved by the full court on 6/3/2017. The fine more than 10 minutes.
Just
1 second. Should we finish with the finish now? Should we finish? Of appointment shoot?
Have been working
because there are no interim order.
from
So those those who are appointed, then they are continuing in service.
1 year service in the 1 year training in the Judicial Academy in first year. Then they are posted.
You can't disturb the posting.
So now you are, and your clients are out all these years.
Out all these years.
Now those people are already in since 2017.
I scored high in the written test.
Now, Mr. Chidambaresh, the only problem,
6 years.
6 years, these chaps have been working now in the district judges, as in the judiciary, right?
That was my
These are recruitment to civil judge, junior division.
Milord, my
District judge.
Milord, my anxiety is only
This
this.
is a lateral entry to the district judges.
I know it will be difficult to displace them now. I know, but the problem is this. one among the petitioners is doing exceptionally well at the bar. Chances of being elevated.
Is, prima facie, what is, of course, we'll hear the High Court lawyer. Who's appearing for the Kerala High Court? Jose, no?
Sheshadri Naidu, who said he wants.
Sheshadri is appearing. All right, no problem.
You can ask.
Now, Mr. Chidambaresh, assuming that you are right, this issue of change of the rules midway, strictly speaking, is a subsidiary issue. Yes, they did change the rules midway because it was after the Viva Voce was conducted that they introduced this minimum cutoff for the Viva as in terms similar as the written exam. But more important in this case is the fact that the minimum cutoff which they imposed for the Viva was directly contrary to the rule 2C3.
Scheme of examination also stipulates that.
Now, Mr. Chidambaresh, having said that, we just look at the scheme of examination in a minute. So really speaking, the reference may not arise in this matter. Two, if you are right, subject to hearing Sheshadri, if you are right, the decision of the High Court to introduce a minimum cutoff was contrary to Rule 2C3. But third, coming to the grant of relief, at the end of 6 years now, when these people are working, we may not be inclined to disturb those who are already working. What we could do is this. We will say that many of your clients would have now joined the bar. Probably all of 4 of them have joined the bar. If they are good, they may even aspire to becoming High Court judges in future. We will clarify that our decision not to grant you relief has no bearing on your intrinsic merits. And therefore, the fact that you did not ultimately qualify in this examination will not be future.
That is my apprehension also.
For all we know, any of you may become High Court judges tomorrow.
Hopefully.
Yes, we've had High Court district judges who who resigned, joined the bar, and then became High Court judges.
Yes.
Okay. How many in this batch of 4 matters? No, there are only how many petitioners are there?
10.
They are here before us. But everybody is served.
My lords, in fact, in 215, although it appears for the Gujarat High
Shraddha,
Court.
one second. Shraddha, one. But the fact that R9, 11, and 12 much below. But the fact still remains that now they've been working as district judges for the last 7 years. Many of them would be now virtually coming on the threshold of becoming High Court judges,
Whereas you would have joined the bar or seen something else, because 6 years wouldn't have gone by without.
All right, look at it from your point of view. Suppose we appoint you as district judges today, or we say that you should be appointed. We can't give you seniority of 2017. Your seniority will come today. But I know they are okay because today this is such a valuable employment under the state. But the point is that, now to displace people who are working, after all, they've worked as district judges for.
There's another issue. There is a human problem involved, my lords. 6 years they are expecting, and the practice also, my lords, side by side.
Dinesh, you're absolutely right. No doubt about it. We are completely with you on that. But, now we have to look at both sides, You have on the other hand, people who are working as district judges for 6 years now to tell them you go home. And after working you tell me to join the bar today, I don't know what will happen to me, because if I don't think I can answer questions of judges as Brother Narasimha was answering until recently.
Narasimha is the only exception.
How will these people even go back to the bar after having been judges for 7 years? It's very difficult to go back to the bar and start a new career.
If it were a selection which is arising immediately thereafter, perhaps we would have asked the High Court to give them some kind of a concession or relaxation and take them in. But then this period of 6 years is something we can't tell the High Court to, in the next selection, give a priority or some kind of.
6 years is too long.
Oh, after 16 years.
You lose seniority in so many things. In service. You see, I was just telling Honorable Chief Justice, for all you know, this decision of the administrative committee might facilitate those who are in practice to come into the bench of the High Court faster than these people who have been selected as district judge. Possible. No. One is just saying, to upset those who are already working.
Can't upset. Mr. Nataraj, you are the one person who is disconnected from the matter in the sense that you are appearing as law officer.
Yes.
What is to be done? You've been hearing the facts.
Some of the persons should still, they are interested, without disturbing them, they can be accommodated at least in the coming this one. Because already they have.
Also, how do we do that?
And we have already held that it can't be done because
Because
there are
some
future
selection
prospects of
team,
the younger generation which is now ready.
3 vacancies will be taken away from a future selection, for which there would be people who are willing to apply today.
Unduly,
They were not qualified.
they are denied. So one thing.
My Lordship, may only say on behalf of petition number 4, my Lordship, in this particular same set of Kerala matters, Petition number 4, my lordship, she is not only a widow. The challenge is that, my lordship, she belongs to OBC community. What has happened, my lordship? The process is now brought to the fore. A new community, or from the communal reservation as per the number of Muslims as well. Now, what has happened, my lordship, is there's an entire under-inclusion which is coming through with this. And here the
Give it to the High Court. Give it to the High Court and then do it, and you can't get
all these people may have had an opportunity with Viva. My lordship is right. Aggregate question of whether the marks been taken together, includes for the Viva and the written, my lordship. Yes, there is an aggregation there. But the challenge here is, my lordship, what has now happened in the process, the consequence which has now come in, my lordship, is that some of the more worthier candidates today stand eliminated entirely. And
you are eliminated.
to the extent, my lordship, today what is happening is, my lordship is like, coming to the bar. Now, what happened is, my lordship, last occasion, when matter before my lordship, before Justice Banerjee, as a matter should have been resolved. What has happened, my lordship, the matter has been
Right, it's been pending for, had we taken up this matter when the reference was made, we would have said, all right, there are no equities, they were just come in 1 year ago. See the judicial process,
My lordship is rightly mindful of the other persons who've gone in on the bench, but my lordship, consideration of these candidates.
2018, 18 maybe they could have allowed the petition. That time it would have been. If the petition was allowed in 2018, it may have been much more equitable because, these people had just joined in 2017. I mean, there was no equity in their favor. But now by the pendency of this reference for 5 years, Mr. Sheshadri, is he online? Shraddha, who are you appearing for?
My lords, I'm appearing in the petition for the Gujarat High Court, and the scenario in our case is, my lords, that there were 219 posts that were advertised.
A little later. We'll deal with this. We are not dealing with this on issues.
My lords, the only reason I wanted to state is because in our case, this was 2022, and there are in fact 160 posts that are still lying vacant because only 55 candidates out of 219 posts have been selected. And in fact, my lords, the total marks secured by my clients is far higher than the marks secured by the persons who have been selected. For example, my lords, petitioner number 2 in my case, in the written test alone, secured 142 marks, which is what rank 23 has secured.
You are in the same as Mr. Chidambaresh, Mr. P.V. Dinesh, but perhaps you are saying your marks are even better than...
Even higher, my lords. Even in rank, if the cumulative score would have been taken, I would have been in the merit list of top 10 candidates.
2022. You are 2022.
Yes, my lords.
So it's just one year back.
Yes, my lords. And in fact, there are only 55.
We will deal with your case separately. We'll complete this. Now we'll hear Mr. Naidu. I think Mr. Naidu is online.
Is he online? So Ramesh, is he there? Okay, can you tell us?
Dama Sheshadri Naidu.
You can दिखाया क्या? Dama Sheshadri नहीं.
Just send message.
All right, we'll ask Naidu.
So far as accommodating is considering the facts and circumstances, take a decision on how to accommodate them with sympathetically.
If anybody
just check whether yes, anybody is interested. वो जरा check करने को बोल दो ना Naidu को phone करके. If anybody has Mr. Naidu's phone, just give him a call and say that he can join. We are waiting for him. Huh? All right. चलो खत्म कर देंगे अभी dictate कर ही देंगे. We are not interfering. Whatever future is dates.
Trying to join through court, Mr. Naidu is trying to join through. It is connected through court.
Reference order of Bhanumati. In 2000. Bhanumati would have referred it in 2018. No? To see in Joseph and Bhanumati. No? Judgment reserved.
Yes, yes, yes.
2nd November, 14 November. Yes, I got it.
In the meantime, can I point out two other provisions in the scheme?
You wanted to show us the scheme, right?
Yes.
Yeah, no, we'll just see the scheme. Huh?
But in the
What page is the
it
scheme?
is 501.7.
No, the scheme will be there in Dinesh's compilation also.
In not the in 501.7 paper book.
Yes.
It starts at page 26. 25. PDF page number 33.
501.7. 501 point. Yes. 51. 62. 62.
Scheme of examination as amended by the full court minutes dated 13/12/2010. Cut-off mark. The candidate need not secure any separate minimum marks for each paper. The general candidates who secure 50% and SC/ST candidates who secure 40% aggregate minimum for both the papers shall be declared as qualified for the Viva OC examination. Then, further down below, written examination. The Kerala Higher Judicial Service examination will have a written examination for two papers carrying 150 marks each and a Viva OC carrying 50 marks. Then,
yes. My lords, can I be heard?
Further
yes,
down.
Mr. Naidu, just 1 minute. We'll come to you in a moment.
Further down below, with regard to Viva
My
OC.
lords,
Just 1 second. 1 second. Yes. Where is it at? Where is the reference to Viva? Yes, at page 28 bottom. That is page 65 bottom.
The Viva OC test should be in a thorough and scientific manner, and it should be taken anything between 25 and 30 minutes for each candidate. There shall be no cut-off marks for the Viva OC. Explicit in black and white. There shall be no cut-off marks for the Viva OC, which was not pointed out before your lordships earlier. Viva OC shall be conducted by a board of honorable judge constituted for that purpose. The merit list will be prepared on the basis of marks obtained both in the written examination and Viva OC. Then, your lordship will get the notification.
39:15.
The notification starts at?
Next page is 31.
Yes. Mode of selection. At page 32 deals with the mode of selection. Then at page 33, if the number of applicants the merit list, page 33 begins like this. The merit list of successful candidates will be prepared on the basis of total marks obtained in the written examination and Viva OC.
Where is that?
33 at the top.
If the number of applicants.
If the number of applicants is disproportionately large vis-a-vis the number of posts to be filled up, the High Court reserves the right to shortlist the candidates by their length of practice at the bar. And such shortlisted candidates alone will be called for the written examination. The power to shortlist is there, but only on one contingency, only on one criteria, depending on their length of service, nothing else, not on the basis of marks in the Viva OC.
And this has not been varied.
And this has not been varied.
Nor the scheme.
Nor the scheme.
Perhaps it is actually variation.
It is a variation. Because that was approved by the AC, by the full application use.
Will you kindly see the language of the minutes of the full court, or minutes of the administrative committee? That is at page 46. 46. Paragraph 2. The administrative committee meticulously examined the marks awarded to each candidate in the Viva OC by the members of the selection committee under the above 6 different heads. After such examination, the committee is satisfied that the prime consideration of the selection committee while awarding marks in the Viva OC was the suitability of candidates to man the notified post. It is the ultimate object of a Viva OC to weed out incompetent and unsuitable persons who may squeeze into the service by mugging up answers in the written examination. This elevation to the bench, squeezing into the service. The Katanoff decisions of the apex court also lays down the above salutary principle. So the committee is of the firm view that the stipulation of 50%, 40% marks respectively for the general and SC/ST candidates in clause 5 of the notification in the present selection and similar clauses in the other notification for which the common examination was conducted is essentially applicable to the Viva OC examination also. Then towards the middle of the next paragraph. The split up of marks under the 6 different categories. 6 different categories are knowledge, skills, attitude, ethics, communication, character. The split up of marks under the 6 different categories will indicate that 30 out of the total 50 marks is for the first 2 categories, which are of permanent importance for a judicial officer in the cadre of a district judge. The candidates who had obtained less than 50% marks in the Viva OC had fared very badly in the above 2 categories, and whatever little marks they had obtained are mainly under the remaining 4 less important heads. And therefore, the committee is of the firm view that they are not suitable to man the post to which the recruitment is carried out. Recruiting such persons will be disservice to the public at large, which was not the intention of the full court. The beginning of the minutes also, para 1. The administrative committee, previous page, the administrative committee considered the marks secured by the candidate in the Viva OC examination. Though in the scheme approved by the full court on 13/12/2012, it is stipulated that there shall be no cut-off marks for the Viva OC. It is not an empty formality. Viva OC is expected to be conducted in a thorough and scientific manner. Each candidate has to be interviewed for 25 to 30 minutes, 6 different heads under which the heads marks are to be awarded, and the maximum marks that can be awarded under these heads are also stipulated. So it is clear that certain minimum standards are expected from the candidates without which they cannot be found suitable for the above post.
Mr. Naidu. Thank you, Mr. Chidambaram.
Yes, my apologies. And it's nothing short of foolhardiness and audacity on my part being absent. I was away minutes because I thought my turn would be later.
You were in greener pastures, Mr. Sheshadri. Yes.
Yes, minutes.
Yes.
Minutes.
What you have to
It
say.
seems something fell from your lordship. That's what I was told. Minutes. I gathered that without any stigmatic remarks, could they be dispensed with? Because Millets, we took a conscious decision in the full court.
Sheshadri, we are inclined to take the view that the High Court decision is completely wrong. For the reason, first and foremost, that Rule 2C3 specifically says that the selection will be made on the basis of the aggregate marks which are obtained in the written test and the Viva. Now, if that is applied, what you have basically done is that, forget the fact that the decision was taken midway through the selection process. We'll leave that aside for a moment.
Yes.
What you did was you said by the full court decision that the minimum cutoff which has been prescribed for the written exam shall also apply to the Viva. As a result of this, what happens is that those who get selected actually, as a result of this, those who get eliminated on the survivor. In other words, what you have done is plainly contrary to Rule 2C3.
First of all, it is contrary to the rule.
All
Number two, the scheme specifically provided a distinct method which is to be followed, and cutoff mark was not permissible. Number three, the notification said that if there are overwhelming numbers, then we will go only by the number of years in the bar. Answer to the fact that the decision of the High Court is wrong.
Millets, only when we went to the hustings, we realized the practical difficulties and the impossibility of those. I submit, Millets, it's true that the rule stares at us, but the problem is this, Millets, in the overall interest and the efficacy of the adjudication at the lower levels, Millets, at the district level, we had to take this step consciously. All the full court unanimously. But the difficulty, I'll submit, Millets, the tendency has grown recently that, and then they score very high in the written examination. When faced in the Viva interview, Millets, which is the vital part as to their practical knowledge, they've been absolute zero.
It's specifically in the rule. Nobody goes by, nobody is challenging the desirability of having a cutoff of a minimum marks in the Viva state. But you must then specify it in your rule, which you have subsequently done in 2017.
But your notifications and practice in the bar will be the.
Yeah. And you know, your
I reckon, Millets, when it comes to the appointment of the higher judiciary in the sense of district judges, it may not be an ordinary post. Millets.
Sheshadi, the scheme specifically says that the shortlisting will be made on the basis of the years of practice in the bar if the number of candidates is unusually large.
Specifically provided that the cutoff marks for interview is not permitted under the scheme. You have said it.
Millets, it's an exceptional decision under exceptional circumstances, only in the interest of efficacy at the district level, because they had all been young. And
We'll come. It's we'll come back and dictate a short order after lunch in this matter. So 4 matters of Kerala will be over. Instead of starting now and come back after, dictate it after lunch.
Great.
May I have your lordship's leave?
Yes, Mr.
503 is that arbitration matter. On the 14th of June, government has appointed an expert committee to look into various issues. One of them would be this arbitral appointment process. Mr. Khalid has joined me virtually, and they moved an application before the Unsipsal National Committee. The lordship thinks that the matter can be deferred for a while till the committee gives a report. Then we'll have the wisdom of what's happened. It's a consultative process.
That is serial number 502.
502.
Mr. Nariman has joined. Mr. Nariman, the Attorney General was suggesting that we
Yes, and
cancel the hearing 502.
that would be preferable because, my lord, the reference by government is really for a new law to be enacted. That seems to be the memorandum of the government. So we don't know whether a new law will be enacted or not, so that the present reference about whether the bench of 3 judges on the one side is right or a bench of 3 judges on the other side is right, it is idle. It'll only take up much of your lordship's time.
What we can do is we can defer the hearing of 502. Who's on the other side for 502? So maybe we can.
504, both are together.
But what is the timeline? How long do you want us?
What I would suggest is, I think the committee should not take more than 2 months. And let me also try to expedite the proceedings of the committee. We'll give a report back to the committee, back to the court. As soon as the committee deliberations reach a conclusion as far as particular issue is concerned, the manual lordship can take a decision on convening the court.
And the remit of the committee is to reconsider all the provisions of the Arbitration and Conciliation Act.
It's a very fairly large number of questions, but this question is incidentally also important.
It is not confined only to the issues.
No, there are other questions.
Other questions.
But I request the committee to focus on this question as early as possible.
And what is the date on which the committee was constituted by the government?
20th June. 14th of June. 14th of June.
Mr. R. Venkatramani.
This finds a reference in an application. There is an office memorandum dated 14th of June 2020.
Mr. R. Venkatramani submits that on 14 June 2023, the Union government has constituted an expert committee with a broad remit to consider the provisions of the Arbitration and Conciliation Act 1996. Full stop. The Attorney General states that, submits that in view of the the issues which have been raised in the reference to the Constitution bench would undoubtedly also come within the broad framework underlying the Constitution of the committee. Full stop. After the report of the committee, the government would take a considered view on the modification of the legislation is warranted.
What is 504 says?
Yes, we are saying for 502 and 504.
Lordship.
504.
Mr. F.S. Nariman, Learned Senior Counsel, has also joined in making the same submission, as have the counsel appearing on behalf of the other parties. Hence, presently, we direct that the proceedings in the 2 references to the Constitution bench be deferred by a period of 2 months.
Your Lordship.
Full stop. The court shall be apprised on the next date of the progress which has been made following the constitution of the committee.
Fair enough.
So we'll list it, give a particular date. We are now in towards the middle of July, August, September. We can keep it sometime around the
End of September.
Can keep it on the 13th of September, which is a Wednesday, I think. 13th of September.
Yes, that's all right. Yes, certainly. Lordship, please.
Why is the committee to take into account the recommendation which we would give?
So there's needless.
The committee is bound to do that.
They're receiving a
different issue.
large number of.
That's a holistic consultation that will go on.
There's Mr. Banerjee says that. And this aspect can also be taken into account. And I hope you're also looking at the issue of the stamping of the arbitration agreement.
Yeah. What?
Stamping of the arbitration.
I see.
Not court's power.
Who's sitting on his left?
Roy. This is, here is Narasimha, Narasimha, here is Roy. This is talking.
No, next.
Lordship.
One minute, just. Item 501 has a batch of 17 matters relating to appointments in the judicial service.
Yes.
I appear for respondent 501.4 on behalf of Manipur High Court, my lord. Though I am the respondent, my lord, but then the questions which arises for your lordship's consideration before the Constitution bench, I have formulated 6 questions circulated to your lordships and circulated to all my colleagues also, my lord. If your lordship so pleases, my lord, I can explain, my lord, because I have prepared a chart also of all the matters which are listed. They are coming from 6 different high courts. And Lord, what are the issues? I've just said in one sentence.
Now tell us 1 second. Now we just take a roll call of who's appearing in which matter. 501, who's appearing?
Lordship, I am appearing for 501 as the lead matter. And Lordship, I am not from the judiciary, I am the clerical staff of High Court. Lordship, I am different from others.
Go, let's go one
by one. Yes.
501.
Lordship, I am there. I am for the petitioner. I am my matter 501 and 501.9. Lordship, now in this matter, the matter.
You're for the petitioner there?
I prepared a list of matters, lordship.
And Lordship,
Mr. Hansari, you've got a list of who's appearing in all matters? Just
not who's appearing, but which.
Okay, just give us that so we can write on that.
It deals with.
All right, excellent.
For example, my lord.
Just 1 second.
Yes.
Let's at least, so that we have, there are 17 matters. Okay, so 501.
501
Lordship,
is.
actually,
there are
I am
four
different.
matters.
Different.
1 second, ma'am.
we'll call you.
501 is Tej Prakash Pathak versus Rajasthan High Court.
This relates to, my lord, appointment of
Translators in the High Court. Okay.
501.8, there are 4 matters from Rajasthan. It relates to National Talent Search Examination, granting scholarship to class 10 students. 501.9, appointment of translators, and 501.10, appointment of translators. So 501, 501.9, and 501.10 are same. 501.8 is little different. Then second, Patna High Court, my lord, it relates to the same, my lord. 501.1 and 501.12, selection of district judge entry level in 2015-16.
Both same.
Then there are 3 matters of Guwahati High Court, selection of district judge entry level in 2011. Like same selection, 501.2, 501.3, 501.11. Then Lord, 1 matter from Manipur High Court in which I am appearing, 501.4, selection of district judge entry level in 2015. Where, my lord, there is a judgment, my lord, where the difference of opinion between 2 honorable judges of this honorable court, detailed judgment. It was referred to, my lord, a larger bench, and then the 3 judges referred it to, my lord, a larger bench because of the pendency of this.
So it is in this that it arises, the reference order.
Reference is on the first matter, my lord.
This has no reference order.
Tej Prakash, Rajasthan.
Manipur has no reference order.
And 501.4, the 2 judges deferred. It went to 3. 3 said place it before 5.
Yes, my lord.
In view of the reference in Tej.
In view of the reference in the first matter.
There are 2 other issues which arise in the matter which I'll point out.
All
The
right.
petition amendments.
All right.
Then 5 is, my lord, Kerala High Court. Again, my lord, relates to district judges selection in 2017. 4 matters, my lord, same selection. And the 5th is from Gujarat High Court. Selection of post of district judge junior division in 2021 and 2022. 3 matters from there.
So except for 501.8, which deals with the National Council for Educational Research and Training, all other matters pertain to the high courts.
Please allow it.
I mean, high courts as the case may be the district judiciary.
Yes.
All right.
Yes.
Now you've formulated now just to have us.
If I may intervene,
Just 1 second. Don't talk out of turn. Now tell us now among these seniors who are appearing, just let's have an idea of who is appearing on this side and who is appearing on the other side. Who is appearing in support of the plea which the high courts are taking? We have Mr. Vijay Hansaria for the state of Manipur.
Manipur High Court.
Just 1 second. Let's take that down.
High Court of Manipur, not state.
Sorry. Yes.
Yes.
So we have Mr. Vijay Hansaria for the High Court of Manipur. Then who's appearing for the Rajasthan High Court? All right, Mr. Puneet Jain? Sunil Kumar Jain. For the Rajasthan High Court. Right. Okay, that we got. Now, who's appearing for the Patna High Court? Mr. Gaurav Agarwal.
It doesn't arise, it's to matter. If I leave it to the petitioners to ask, is that there's an application actually to detach this matter.
Oh, I see.
1.1, because this issue doesn't arise, but I leave
Yes,
it.
but that's an issue pertaining to evaluation process. This is not concerning to the matters which are listed here.
So we can then detach the Patna High Court matter?
Yes, this issue of rule of change of rules of the game doesn't apply there, but subject to the petitioners arguing. They can still argue.
Mr. Sharma is in fact appearing in
501.1.
Who's appearing for the petitions in 501.12?
According to me, the broad questions to then all the High Court assist your lordship. Because the issues
Fair
arise,
enough.
will have an impact on.
Mr. Agarwal, are you ready? You are ready with the point also, right?
There's no material on the basis on which it has to be argued. I'm here.
No, on the principle.
This doesn't arise, so I don't know. I can address your lordship generally.
To assist us. That's what I was. So we will say that we will delink 501.1. What we will do is we'll retain 501.1 and 501.12 on the board.
Please do.
All right. Because we also want to ensure that our counsel who assist us can sort of mark a docket at the end of the hearing. So,
Pleasure to assist.
So we like, all right. So, and then at the end, we will delink, go yaad rakhna, 501.1 and 501.12 will, I think we'll delink. Now, so we got now the
Also 501.15, my lords.
Just
I
one
apologize to
second.
interrupt. I apologize.
Now, Guwahati, who's appearing for the High Court? Mr. Jose, right? Mr. Jose is 201. Mr. Jose, yes. Right. And then we are left with which High Court? Kerala.
Yes.
Kerala and Gujarat.
And Manipur.
My lords, for Gujarat High Court, I appear in 501.15. My lords, this is also a separate matter where the 2011 rules of the Gujarat judicial examination has been challenged. The rules of the game question is not an issue here, my lords.
Oh, 201 point?
501.15, my lords, which is Kirti Agarwal and others versus High Court of Gujarat.
Same in 501.16. Does this issue arise in one court? That arises.
My lords, in fact, in point 15, the same question with respect to the challenge to the rules is pending before another bench, my lords, in writ petition civil number 663 of 2021, my lords. So our matter may be tagged along with that and be heard along with that, my lords, because this question is similar to the question being decided therein.
What we will do is we will just detach these matters. So 501.15, maybe we will detach them at the end. Yes, because, after the arguments are heard, very briefly in 2 minutes, we look at all the matters and then decide what is to be detagged. Because for all we know that, something might, incidentally arise here. So,
overlap quite a few.
May I come in for Manipur for half a minute?
Just 1 second. So for Gujarat, we have Shraddha Deshmukh. Anybody else for the Gujarat High Court in these three matters? Shraddha, you are appearing for all the three matters?
My lords, I'm appearing for the petitioners in this case, not for the Gujarat.
For the High Court. Petitioners, anybody who's for Gujarat? All right. In Rajasthan, we have Sunil Kumar Jain and Pawan Shrivastawa. So we have now the list of people who are arguing for the High Court.
Manipur, I need to clarify something.
Yes.
Manipur matters, there is a difference of opinion.
Party is
501.4.
Yes.
Whereas Manipur High Court, the slight difference in this matter is stage Prakash would be stage 2 if stage 1 is crossed, because the judges differed on all 3 points which were raised in the matter. This is Bhanumati Ashi then was held against us, against the petitioner. Justice Shivkiti Singh as he then was held in our favor on all 3 points. They differed on all 3 points. So stage 1 was whether they, by executive instructions, 309 rules could be overridden. That's the stage 1. If they cross that, then stage Prakash would come. The rules of the game is the second stage at that, and then procedural unfairness. On all 3 issues were raised before the court.
Therefore, we have to decide the constitution. We'll keep this matter with us.
Yes, madam.
Because our decision on stage 2,
yes,
you're right, it may not arise until stage 1 is crossed.
That's right.
But we'd like to have the assistance on
Very
stage
well, I'll
2.
be here. I'll be here on
And
that.
eventually we'll send it to the 2-judge bench. The
3 judges because of the
3 judges. Yes, the 3-judge bench.
I just wanted to place it on record so that it's not that we have to only argue Tej Prakash. We have
that is a serial number?
That is 501.4. That's the Manipur.
Go to the 3 judges.
Manipur.
The larger issue is of the full court reference recommendation, which did not amend the rules. I'll argue that also, if you watch it to
all right. And Mr. Natraj, who are you appearing for?
Although in the matters with direct role in the particular issue, but the larger issue.
We'll require your assistance on that. So you please be there so that, because this also affect you in other service matters. It just so happens that these are broadly only High Court matters except for one issue.
Apart from this was not it was challenged by the included in the final deciding the color. It was granted by Rasan High Court and
that nothing apart from the English marks could be considered.
the is that the English mark earlier was, but first time the committee has decided making the English qualifying mark, considering overall impact of all are not.
All right, that's our individual facts. We really need to address on the. Anyway, we're not looking at individual cases. We'll see the case. So now, what we can.
No.
All right. All right. All right. So what we'll do now is this. The lawyers who are appearing for the private parties in all these matters, please give us your appearances on a slip of paper. We just wanted to know, broadly, who's appearing for the High Court so that we have everybody present here to at least start the arguments. So now, we can hear Mr. Vijay Hansaria for the High Court. Yes, Mr. Nataraj, would you like to go first, or Mr. Hansaria will argue first so that you have some, because you don't have a live matter.
Our role might come only later.
All right, so we can hear Mr. Hansaria, then we can hear Mr. Who would like to go after that? Mr. Sunil Kumar Jain. Then we have Gaurav Agarwal, Jose, Sheshadri Naidu, and Dipandita. So 5 councillors.
Would you like to hear the petitioners first, because
we can do that, no difficulty.
Because that's because they'll have to respond to the changes that they are supposed to have made in each High Court.
So what we can do is we can only request Mr. Hansaria, who has formulated the questions, to show us what his formulation is. We can share it with all of you. If somebody wants some little change, you can someone here on that. And for the petitioners, Haripriya, will you just take it upon yourself to tell us, Mr. Chidambaresh? Mr. Chidambaresh will be appearing for the petitioners in the Kerala matter. All right. Who are going to be appearing for the petitioners, and how long would you take? So we'll start then with the petitioners, because technically, you have to start first.
I've seen the questions, my lord.
No, whoever is wanting to appear on this.
Who's for the petitioners now? Tell
Give
us.
her the details so that you will collate and then tell us.
Now, for the petitioners, who will open the arguments?
Kerala Metro, I know. Because my item is 05 and 06, 501. Petition.
You are in 06 for the petitioners.
Because 5 and 6, there are back to the matter. 5 and 6.
So Kerala for the petitioners, Dinesh, Haripriya, and Ragan Basant are going to be appearing. Mr. Chidambaresh also. All right, no problem. We'll hear you. Now, in the other cases, for Rajasthan, Patna, Guwahati, and Gujarat, who are for the petitioners?
I am for the Patna. Petitioner in Patna High Court matter.
So on the side of the petitioners, please give your not appearances, but just a small note to Ms. Haripriya Padmanabhan, so she can prepare it in a consolidated way and give it to us so that we can call out matters seriatim then.
I would
State-wise. Right. So on behalf of the state, on behalf of the petitioners, we'll go state-wise. All right. So we can perhaps do Kerala first, है ना? I think Kerala will be better, because you have Chidambaram, you have Dinesh, you have also.
I would rather have Manipur at the end, my lords, because
All
I have
right.
some additional points.
No problem, Mr.
Independent of those
Mukherjee.
6 questions, which are
Absolutely.
formulated and given to you.
So
All
we'll
right.
do Kerala first.
We'll do Kerala.
So either in the beginning or in the end, because I am the clerical staff and I am different from others.
All right.
Tej Prakash here.
We'll take up each set. So what we will do now is, so first we will take up Kerala.
Look, I have formulated the question.
Just once again. So the order will be, we will first take up Kerala, then we will take up Rajasthan, then we can take up.
Subject to your lordship, please. What I was submitting is, my lord, the submissions.
Just one second. Broadly, we'll just tell you. We'll take up Kerala, Rajasthan, Patna, then Guwahati. Then we can say tentatively Guwahati, Manipur, and Gujarat and Manipur. Yes.
What?
Yes.
You can't be converting Assam, it's Guwahati High Court, it's not Assam High Court.
Yeah, it is Guwahati High Court.
Can I point out? May I point out one thing?
Mrs. Naidu will be available only in the afternoon, for appearing.
Petitioners are going to.
Petitioners are starting. And Mr. Naidu is for the High Court, so he can come.
May I point out one thing?
Yes.
All this batch of matters,
Kerala, Rajasthan, Patna, Guwahati, Gujarat and Manipur.
in all these batch of matters, the situations are different from each high courts where they have interpreted.
Right.
So ultimately, the reference is also, I mean, bit vague, unless what exactly is the reference and how it is applicable.
Read the reference order.
Here.
We'll read the reference order by Justice Chalmeshwar's. Yes.
Yes. And the fact situations each.
Then
case-
we will have to see a little bit of the fact situation for all the states actually, because we can't just decide it in the abstract. All right. Yeah. Some of the broad. Sorry, now should we have a look at what you have prepared?
Yes,
so
Lord.
that we can get started.
And finally, filed a written submissions on behalf of Manipur High Court. Writ petition 294 of 51. Yes.
Let's see what they formulated. तारीख के 12 में. Next 12.
Yes.
Yours is a 6-page folder?
Yes, 6-page note, my lord. Yes. And there is compilation of, my lord, the case laws which has been shared with all my colleagues also.
Just one. The 6-page note, yes.
My lord, sir. The following questions arise for consideration of this honorable court in the present set of matters. 1. Whether the selection of judges of the district judiciary and staff, and including staff because one of the matters related translators. Cut-off marks can be fixed for both written examination for viva voce examination, and a candidate to be included in the select list must secure the minimum qualifying marks for both written and viva. Because, my lord, one of the argument of the petitioner side is, my lord, the SETI commission says there should be no minimum for viva, which, as per the argument, all India judges is accepted. We have some submission to make. That's one issue which arises. Whether the cutoff marks must mandatorily be fixed in the service rules or can be fixed by the executive order issued by the High Court. Whether in changing the cutoff mark after the selection process is started amounts to changing the rules of the game and is impermissible in law. Whether the selection is based, where the selection is based both on written and viva, what should be the proportion of marks to the main written examination and viva votes, and what should be the percentage of cut-off marks for the written examination for the viva votes? Whether the marks,
all these issues, do they arise in the before the constitution bench?
They need not.
yes,
You may have collated it.
Manipur is separate, but that's what I'm
That's
trying
right.
to impress.
Mr. Hansaria, you may have
So it's slightly
collated all,
separate
you
matters.
may have formulated it
yes,
on the basis of issues arising in
The
this
case.
batch of matters
yes, my lord.
put together. But then the reference is on the basis of the judgment of Chalameshwar.
Yes,
He refers.
Essentially, the question, my lord, whether the rules of the game can be changed
For
after
example,
the rules
Manipur
change.
matter is also
That is the reference.
placed before the constitution bench.
We'll see the, so therefore Manipur also will see.
Manipur,
where the
that's why I
three
reserve my
bench-
right to respond to this. These questions do not directly arise in Manipur. Tej Prakash is instantly there. So I'll have to make good. That's why I want to come in at the end.
So ideally,
I
I
want to come
think what
in-
we must do is we must look at the reference order,
Yes, absolutely.
and having looked at the reference order, then we will look at the individual state facts. You see, we'll take up each individual state, and we are going to go, as I said, first
Two more questions, my lord. Can I
to
just
the
complete
Kerala
it?
High
Yeah,
Court.
then take your lordship to the reference order.
Yes.
Just two more questions, my lord,
Yes.
on the next page, page 2. Whether
Because
the-
we shouldn't be answering questions which really arise before a 2 or 3 judge bench, in that case.
That would be actually proper.
Yeah.
Broaden the scope of the reference also.
That's why
But can I come?
my submission in Manipur is Tej Prakash is not directly attracted to it. It comes as stage 2. So therefore, you have to cross the first threshold. And that is not before your lordships.
All right,
Study-
what,
Let us read the reference question first,
I will just.
so
show
that
from
we
the
confine ourselves to what is to be answered.
Yes, my lord. I will
Because there could be peripheral issues in any of the cases.
Yes, that's, just two more questions and then I'll go straight away go to the Tej Prakash, my lord, reference. order.
you wanted to read the last 2 questions, right?
Yes, my lord. And then I'll take your lordship to the reference order, my lord. Whether the marks of the written examination should be published and or made available to the members of the interview board before awarding the marks in the viva. But 2 of your judgments says, my lord, that it should not be made available. There are 2 judgments of your lordship's court. Whether a candidate has an indefeasible right to be appointed if she has been considered for viva and or her name is included in the select list, and whether the High Court as an employer is bound to fill all the vacancies notified in the advertisement.
All right, now we've got your point. Now, just one second, Mr. Hansaria.
Yes.
Now, what we'll do is, we will take up Kerala first.
Very
Can we go straight now to Kerala for a moment? Who's going to open arguments for Kerala?
I'll open
Dinesh, you are opening arguments for Kerala?
Yes, my lord.
So we'll start with now.
Reference order in Kerala.
Yeah, let's go to the reference order for a second in the.
So Lakshmi, kindly.
Mr. Dinesh, you are appearing. You'll be appearing in.
In 50105 and 06, my lords. But 05 and 06 are batch of matters. So in 06, other my learned friends are also appearing in 06.
So 501.5 and 6, right?
Yes, my lords. That is the lead case in Kerala matter, Shivanand.
The reference order is in 501.5 also in the paper book there.
Yes,
Or
ma'am.
do otherwise we have it in 501. We can read it anywhere.
Compilation of judgments and soft copies available with my lords, filed by Mr. Ansari, my lords. I can refer to that, the soft copy. So everybody can refer to that soft copy, my lords.
You have filed the convenience compilation.
Yes, my
We
lord.
have filed
Mr.
both
Ans-
volumes, my lord.
Mr. Ansari
Right.
has filed.
Files, my lord.
So now,
Party matter, I filed first three, by mistake.
and we've got the convenience compilation.
There are 4 volumes of 1, 2, 3.
Yes, my lords, in fact,
Dinesh, where is the reference order in your convenience compilation?
Let me kindly see convenient compilation part 2. In fact, there are 3 convenient compilations Mr. Ansari has filed, and part 1, part 2, and part 3. I'm referring to part 2, serial numbers 13.
Convenience compilation 2.
Yes.
213.
Yes,
Okay.
serial number 13, Shivanandan CT versus State of Kerala. Short order, my lords. By Honorable Mr. Justice Kurian Joseph and Honorable Mr. Justice Panwal.
PDF 260. Sivanandan, na?
Yes, ma'am. The convenient compilation 525 is the serial number. 2018 1 SEC 213.
मिला आपको? Yes, just get it. Yeah. पंकज में मिला आपको? अच्छा, he will get it for you. You know, in Hansaria's compilation, if you click on Hansaria, you'll get his convenient compilation 1, 2, 3. Huh? Hansaria's compilation. Yes, so that I got. In Hansaria's compilation, yes. Just click on Hansaria. Then there's convenience compilation 1, 2, 61.
The running page of compilation is 526.
Is referring
Always
to compilation.
using PDF,
PDF
numbers,
pages
it's
now.
better.
This PDF compilation, my lords.
Just
526.
go by
526.
PDF. Tell us PDF number.
T526.
Which para you want to?
Please, my lords.
Para?
Lords, this is a reference order, my lords. I already submit, my lords. In fact,
Wait,
yes.
आप मित्तल सबको भी दे दो.
खुल गया है लेकिन. Yeah, sir, just go back. That's your same compilation. Compilation 2 is okay. That's
Questions, my lords?
I got it 259.
259. That is Sivanandan CT versus High Court of Kerala.
Just before reading this, my lords, may I make a submission so that it will be easy, my lords. I'll just 3 minutes. I'll just tell you the facts, my lords, which led to this. Not the basic facts only for the necessary for the issue. My lords, this is in respect of appointment to the post of district and sessions judge in Kerala.
Yes.
And we have a rule which covers the selection process, which is called Kerala State Higher Judicial Service Special Rules 1961.
Yes.
The selection process normally in Kerala, this is in respect of selection of 2015. We are concerned with selection of notification of 2015.
Yes.
Prior to 2015, all those selection process were as per the rules. took place as per the rules. And rule says that the selection will be, because there is a written examination and viva voce. Written examination, there are 2 papers, 150 marks each, and viva voce 50 marks, total 350 marks. Written examination, you have to score general candidates 50%, and exemptions are there for the reserved categories, like 40%. Then only you will be considered for the interview. And the selection will be as per the rule 2C Roman 3, my lords. The criteria for selection is the aggregate of written examination and viva voce will be taken together, and that marks will be the selection for the purpose of selectees. That is the final. And selection happened in the year 2014, same way. And 4 of my clients here, the petitioners in the first matter, there was no cutoff marks so far as interview was concerned as per the rule. 2014, the petitioners, 4 of the petitioners participated. They scored more than 50% in the interview, but aggregate they lost. So the selection committee said, sorry, you don't have aggregate marks. Though you have 50%, they were out. They were not selected. 2015, this selection, 2015 was the notification. Examination was conducted in the month of March 2016. February 2016, my lords. 17 happened. Then I'm sorry, I'll correct my dates. The selection process, the examination was conducted in 2016. Thereafter, the results were declared in December 2016. Out of 400 candidates, 40 candidates scored more than 50%, qualified for the interview. So 40 candidates were declared and they were part of the select list, scoring more than 50% in the written examination. They were called for interview in the next year. An interview took place on 16/1/2017 to 24/1/2017. Yes, 17. Thereafter, my lords, after 8 days, administrative committee met. This is how the issue comes, my lords, here. Administrative committee met on 6th of February 2017. Then administrative committee took a decision that in the interview, the person should score more than 50% marks. That is, they fixed a cutoff mark after the interview took place, after the written examination, as well as the interview. The administrative committee met after a few days of the interview, because then took a decision saying that those candidates who have not scored more than 50% of the interview, so interview became the sole criteria. And thereafter, on 21st of March 2017, the full court met and gave approval to the administrative committee's decision. The selection committee was consisting of 5 senior-most judges of the Honorable High Court. And selection committee and administrative committee, the members are one and the same. They conducted the interview.
So your contention basically is that once the process had begun,
yes,
what they did was that after the interviews were held, they decided to have a cutoff of 50% marks in the interview, which according to you is impermissible.
Then, my lords, what happened? That is, the cliche has been used that rules can be, you can change the rules after the game is played. But in fact, my case would be
after the interview. This is actually after the interview.
This is after the interview. After the interview. And I'll just come to the other aspects, my lords. So my case may not be, the reference itself may not be recurred for the simple reason that it's a straightaway violation of an existing rule. So whether...
What does the rule say, you say?
Rule, my lords, 2C3 of Kerala State Higher Judicial Services Special Rules 1961.
2C small 3.
Yes, my lords.
So rule 2C, what? Small 3.
Yes.
What are the rules called?
My lords, Kerala State Higher Judicial Services Special Rules 1961. My lords, this is a rule under Article 233 read with 309, my lords.
Special rules.
Yes, my lord, special rules.
1960.
Because there is a separate special rule framed under Article 234 But this is a rule framed under Article 233 for the high judiciary, subordinate judiciary.
Rule contemplated taking only the aggregate marks into account.
Rule contemplates very specifically, and that was the practice also followed by the High Court, that the aggregate of written examination and the viva voce should be taken together, and that is the test result.
So your submission is straightforward, saying that the
So my
administrative decision,
Yes, madam.
as well as the selection committee's decision as approved by the full court, is contrary to the rule.
Contrary to the rules.
So really speaking, the issue of
Doesn't arise,
the change in the rules of the game, etc., doesn't arise
This
because
is the race at all, madam.
the rule itself says that you have to take the aggregate.
So my response,
You can't do by an administrative notification what is contrary to the rules.
and all the judgments so far, supported by Honorable High Court and this side, it very specifically says that Your Lordship have held that even 142 Your Lordship may not go against the specific rules, my lords. And we see mistrust in all those cases, my lords.
Mr. Dinesh, was any attempt made to amend the rules thereafter?
In 2017, later on.
Perhaps-
Later on, they fixed 35%. Rule was amended
For the interview.
for the subsequent elections, for the interview.
And for this particular selection of 2015, the
No,
operative rule did not provide us a minimum cutoff
Cutoff
in the
marks.
interview.
Very specifically.
On the contrary, it says that the selection would be made on the basis of the aggregate marks which are obtained in both.
Exactly.
Now,
True,
tell
my
us about the litigation. What happened?
Litigation, I'll just- when we straightaway approached this honorable court in 2017.
32 petition.
Yes, 32 petition, my lords, because there is a contrary. Because what really prompted us to approach this honorable court directly is that all those challenges were pending in the High Court and happens after 5 years or 6 years. So instead, there is a direct contradiction to the rules, my lords. Straightaway we came.
So you filed a writ petition before the Kerala High Court.
Came to this honorable court, in this honorable court.
32 petition.
32 petition.
Then
32 petition, notice was issued, and the arguments took place. And finally, there was there is a reference order. With Tej Prakash was cited, saying that there is a change of rules after the game is played. In that case, as per the Tej Prakash reference order, this should be referred to along with the Tej Prakash case.
So you cited Tej Prakash.
No, my lords, I
Yeah,
could
this
cite
side.
Tej Prakash.
All right.
Then we do it, and Tej Prakash is a case where there is no cutoff date at all for the interview. Cutoff marks at all.
Now
for
tell
the
us one thing, just to argue on the other side,
Yes, madam.
just sort of to elicit your response. The rule says that the selection will be made on the basis of the aggregate marks in the written and the viva
Viva
voce.
voce.
The rule is silent about whether you must also obtain minimum marks in the interview.
Lords,
The rule, according to you, it tacitly also it tacitly excludes the possibility of fixing minimum marks in the interview.
expressly.
Could it not be argued that look, the rule is silent on what the minimum marks in the interview
In
should
that
be?
case, I would like to refer to the rule framed under Article 234, which talks about suitable person can be selected. So there is a question of suitability in 234 rules for the municipal magistrate selections matters. That suitability enables the High Court to fix some criteria. Here it is blank. So there is when you compare 233 rules and 234 rules, my lords, there is an express difference. There is a clarity there, and there is no power given to High Court under 233, even under rules.
It and then ensure that somebody best can be picked up.
For the purpose of
Because
interpretation,
the fixation of the minimum marks in the interview,
for getting the correct candidates, better
right, for
candidates.
getting better, is still consistent with the rule which Yes, Haripin. Yes. Because they've crossed the age bar. These petitions, there are 4 petitioners. But there are totally 10 people like that. Aspect we leave to the High Court. All 11 have crossed the age bar. What about seniority? You're saying you'll forgo everything, fresh appointments.
Ms. Haripriya, there are also elements. It's not just you get into the job. You have to undergo that 1-year training. You lose your seniority. That's one of the things. You know, all across the board in the entire judicial system of Kerala, the prejudice that you are talking about, they will continue to suffer this prejudice of being junior to their batchmates all through their service career. That's also something, although they might be desperate enough to say that please give us even now. And you see, as you lose opportunity by growing older, you gain also opportunities by growing older. I'm just stopping there. And that's Article 14, right? How do you also deprive the people who have qualified in the last 6 years of the vacancies which actually they should be competing for? You are usurping their, see again, it's a cascading thing. It's not just one thing, you see.
The rules today, what do they provide? That
35%.
35% has been provided. When did that amendment come up?
2017.
17, that amendment came in.
It's part of the amendment. There's one more.
Was released.
Is that, by the way, is that that amendment of 2017 somewhere in the compilation, just for the sake of?
Yes, it is there. It is there.
That is document, in case you have it. I mean, it's nothing turns on it.
Your
in
Lordship,
this-
we were submitted detailed submission on the main issue before the Constitution bench as well. Your Lordship will just consider it while passing the final judgment, we'll be grateful. Our submissions are on record.
But we don't need to go into the broader issue of, change in the rules of game here at all.
Not in Kerala case, but it would apply to Tej Prakash as
Other
well.
cases, of course, in fact, in the other cases, if few people are here, you'd like to assist us, you're most welcome to.
Yes, Your Lordship. So it is there in our submission. So as and when the
Ke-
necessity arises.
Kerala case, it doesn't arise strictly speaking.
Yes, Your Lordship.
Which were given to these, in that batch, in the 2017. Was it made subject to the outcome of this petition?
Even today, even this appointment letters all said subject to result of this writ petition. Every single appointment made, even after that, because some of those vacancies carried forward. So every single appointment made, the appointment letter clearly states subject to result of this writ petition, quoting the noms.
Are all of them parties here?
Not three of them, because others won't be affected.
are
So
parties.
we said only 3 will be affected, so only 3 are here.
New release documents. New
Who
release
is appearing
document
for those 3 candidates? The 3 candidates respond numbers 9, 11 and 12.
One, Mr. Kailas.
You are appearing? What do you have to say? Your appointments were made subject to the result of this writ petition, right? That's what you say, yes. Responsible.
Select list. Sorry, no. There was no stay of operation of the select list. Lord, equity, fairness and Lord, justice demands that Lord, they should be allowed to continue. I am not holding that the petitioner should not be given rape. And
Mr. Naidu,
it is not our, sorry.
Please unmute.
Ms. Naidu, please unmute yourself.
No, they have.
Yes.
Yes, please. Now I have been unmuted. Those who have already been in minutes, the candidates that have been selected having discharged judicial functions blemishlessly all these years, they may not be upset.
Now, what about these candidates, who are before us? The left candidates, 7 of them, right?
Yes.
What is to be done about them?
Whether it's a decision, I may be pardoned for repeating, that we have taken consciously, and the full bench has, full court has unanimously accepted that one. And then this decision in the interest of the efficacy of the administration, judicial administration. And we have not played favorites and no mala fides. So such a decision, could it be upset down the line, all these years later?
Can I take 1 minute before I dictate? Just 1 minute. Lord, 3 things, my Lord. One, like a Lordship rightly seen, the rule, the scheme, the notification. Nowhere prescribes minimum marks for write. Now, why I'm saying after the selection 6th March, 5th April, we filed the writ. I'm just saying we have been a vigilant litigant. We filed the writ. The reference order was passed in November 17.
5th of April is the writ petition.
6th March is the selection list, 5th April, with exactly 1 month after.
Give us the date of the new notification.
Yes, my Lord.
Amended notification.
Notification date.
My lord, sir.
What is the date of the notification?
Document number 17. In my
It is a writ petition.
That's document number 17, 20th September 2017.
20th September 17 is the amended.
Yes, amended. Document number 17, black letters numbers 104, my lord.
So 5th April, writ petition is filed. 14 November is a reference order. Now thereafter, we tried mentioning a lot because of the heavy backlog, etc. Matter couldn't get listed. Now if today your lordship finds that the minimum prescribing cutoff marks is not permissible, some relief may be granted to them. I'm not saying I don't want them to go. Ideally, this ideal situation for us is we are there, they are there. But then I'm saying molding the relief, some relief for us. Otherwise, if your lordships today finds that we are the minimum fixation of minimum cutoff marks is wrong and no relief is granted to us, my lord. Frankly speaking, my lord, none of us, maybe benefit from that. So I don't know what can lordship may kindly, with your last experience, do something by which we are also protected. I understand what.
The reality is that
Actually, 6 years.
The full court prescribes saying no cutoff. Administrative committee says, oh, that they would not have meant it. Yes, my lord. So,
don't need to
so only requesting is now that at least the relief, something may be done for us. That's all. I can't say anything.
My lords, on the relief part, one respectful submission, my lords. Apart from this judicial post, my lords, there are a lot of administrative posts as well as tribunals also. Now, motor accident claims tribunal, ILA. So they can be accommodated. So many places, my lord.
expending.
My lords, sir. And
All right,
interestingly, my lords, sir.
I may submit, Millis. I may submit, it may be ironical. Well, they say that relief has to be granted. Well, in fact, principle could be laid down. History bears out in every line of judgment, beginning from Keshwananda Bharati, Maneka Gandhi. Principles have been laid down, but not the relief granted. Because by then, it was not possible.
Mr. Naidu.
As I look at that, bench on 14 November 2017, a bench of 2 judges of this court referred a batch of 4 petitions, which invoked the jurisdiction of this court under Article 32 of the Constitution. The Constitution bench in Sivanandan CT versus High Court of Kerala, 2018, 1 SCC 239. Let's stop. 11 petitioners are before this court, all of whom are candidates aspiring to be selected as district judges in the higher judicial service of the state of Kerala in pursuance of a selection of 2015. Let's stop. In the state of Kerala, The Kerala State Higher Judicial Service Special Rules 1961 came into force on 11 July 1961. These rules have been framed under Articles 233 and 309 of the Constitution. Full stop. The rules provide for three categories. The rules provide for the constitution of the service into three categories. Colon, bracket 1, super time scale district and sessions judges, semicolon, bracket 2, selection grade district and sessions judges, and bracket 3, district and sessions judges, including additional district judges. Full stop. The dispute in the present case, the dispute in the present batch of cases pertains to the third category noted above. Full stop. Rule 2, bracket C, provides for appointment to the third category. Full stop. Rule 2C3 stipulates that 25% of the posts in the category shall be filled by direct recruitment from the bar, into inverted commas, on the basis of aggregate marks stroke grade obtained in a competitive examination and viva voce conducted by the High Court. Inverted commas complete. On 30 September 2015, a notification was issued by the High Court of Kerala, by which applications were invited from qualified candidates for appointment as district and sessions judges in the Kerala State Higher Judicial Service by direct recruitment from the bar. Full stop. Paragraph 5 of the notification provides for the mode of selection. Full stop. Paragraph 5 stipulates that the selection would be on the basis of a competitive examination consisting of a written examination and a viva voce. Full stop. The total marks assigned for the written examination were 300, comprising of 2 papers, each carrying a maximum of 150 marks. Full stop. General candidates and candidates belonging to the OBC category who secured 50%, and SC/ST candidates who secured 40% aggregate minimum marks for both the papers together were to be declared as qualified for the viva voce. Full stop. The maximum marks prescribed for the viva voce were 50. Full stop. Para 5 stipulates that, into inverted commas, the merit list of successful candidates will be prepared on the basis of the total marks obtained in the written examination and viva voce. into invert commas complete. ये आपको मिल जाएगा page 873 in 501.5. The notification किया ना बताया ना आप उसके पहले ही लिख लो आप after the rules of 1961 were notified, comma, the High Court of Kerala had by notification dated 13 December 2012 prescribed the scheme for the examination. Page 26. Yeah. The scheme as notified by the High Court contain the following stipulations. Colon, bracket 1. The Kerala Higher Judicial Service Examination will have a written examination for 2 papers carrying 150 marks each and a viva voce carrying 50 marks with a total of 350 marks so assigned, semicolon, bracket 2. While separate minimum marks were not prescribed for each paper, general category candidates who secured at least 50% in the aggregate and SC/ST candidates who secured at least 40% in the aggregate for both the papers together would be qualified for the viva voce examination. Semicolon, bracket. The viva voce test would be conducted into invert commas in a thorough and scientific manner to invert commas complete for a period ranging between 25 to 30 minutes for each candidate. Semicolon, bracket 4, into invert commas, there shall be no cutoff marks for the viva voce. Semicolon, bracket 5. The merit list would be prepared on the basis of marks obtained both in the written examination and the viva voce. Full stop. Following the notification which was issued by the High Court on 30 September 2015, the written test was conducted on 12 and 13 March 2016. Full stop. On 17 December 2016, the notification regarding candidates who had qualified in the written test came to be published. Full stop. Following this, between 16 January 2017 and 24 January 2017, the viva voce for all the qualified candidates was conducted. Full stop. Next. On 27 February 2017, after the oral interviews, after the viva voce was conducted, the Administrative Committee of the High Court passed a resolution by which it decided to apply the same minimum cutoff of marks which was prescribed for the written examination as an eligibility as a qualifying criteria in the viva voce. Let's stop. In coming to this conclusion, the administrative committee was of the view that since appointments were being made to the higher judicial service, it was necessary to select candidates with the requisite personality and knowledge, which could be ensured by prescribing a cutoff for the viva voce in terms similar to the cutoff which was prescribed for the written examination. Full stop. The resolution of the administrative committee was approved by the full court of the High Court of Kerala on 6 March 2017. Full stop. While approving the decision of the administrative committee, the full court was of the view don't say that. Just leave it at 6 March 2017. Let's stop. The decision of the full court and the resultant promulgation of the list of successful candidates led to the institution of writ petitions before the High Court of Kerala. Before this court under Article 32 of the Constitution on 5 April 2017. Let's stop. The candidates who are before this court are aggrieved by the fact that as a result of the application of the cutoff in the viva voce, they have been ousted from selection, though in the aggregate of marks in the written examination and the viva voce, they would rank higher than many of the candidates who have been selected. Full stop. This specific grievance was urged before this court when notice was issued, particularly in relation to three respondents, respondents 9, 11, and 12. Full stop. When the petition was taken up by a two-judge bench of this court on 14 November 2017, a reference was made to the Constitution bench following an earlier reference made to the larger bench in Tej Prakash Pathak. You have the citation of that? 2013, 4 SEC 540. Full stop. While making a reference to the Constitution bench in the earlier decision, the principal issue which has been addressed is whether it is open in law when a selection process is instituted to change the rules of the game midstream. Full stop. In that context, reliance was placed on an earlier decision in K. Manjushri versus State of Andhra Pradesh and another, 2008, SCC 512. Full stop. The view which has been prima facie expressed, don't say that, the view in Manjushri has been doubted on the ground that the principle which has been laid down in that case would appear to run contrary to an earlier decision in that 1974. Do you have that? Yeah. 1974 to 20. Stop. Next. During the course of the hearing, we have heard arguments on behalf of the petitioners by Mr. P.V. Dinesh, Learned Counsel, Mr. V. Chidambaresh, Learned Senior Counsel, Ms. Haripriya Padmanabhan, and Mr. Ragan Basant. That's the four of you, right? Nobody else? Next. In the view which we are inclined to take in the present case, it does not become necessary to rule on the broader constitutional issue on which a reference has been made in Tej Prasad Pathak. Full stop. The reason why we have come to this conclusion would be elaborated shortly hereafter. Full stop. Principally, the modalities which have been followed by the High Court of Kerala for selection, the course of the process, have been assailed on 4 grounds. Bracket 1, in specifying a cutoff for the viva voce, the High Court has acted in a manner contrary to Rule 2, bracket C, bracket 3 of the Kerala, of the Kerala State Higher Judicial Service Special Rules 1961, to brackets you say 1961 rules. 2, the scheme which was notified by the High Court on 13 December 2012 had expressly provided that there shall be no cutoff for the purposes of the viva voce. 3, according to the scheme which was notified in 2012, the only criteria for shortlisting of candidates, that is the notification, right? This is scheme. Yes. According to the notification, the only criteria for the purpose of shortlisting candidates would be the length of service rendered by candidates at the bar, which was to operate in a situation where the number of candidates was found to be unusually large. Semicolon, and bracket 4, the decision of the decision of the full court of the High Court, or the decision of the full court to prescribe a cutoff for the viva voce was notified much after the viva voce was held, as a consequence of which candidates had no notice that such a requirement would be introduced at the inception of the process. Full stop. Mr. Damasheshasdi Naidu, Learned Senior Counsel, has appeared on behalf of the State of Kerala for the High Court of Kerala, while Mr. Swainso appears for respondent number 9, right? Or 11? 11. Mr. Kailash Nath Pillai appears for respondent number 11. Next. The 1961 rules clearly specify that "25% of the aggregate posts which are to be filled in by direct recruitment from the bar would comprise of the marks obtained, would comprise of the list of candidates selected on the basis of the marks obtained in the aggregate in the written examination and the viva voce." Would stop. These rules, as already noted earlier, have been framed in exercise of the power conferred by Articles 233 and 309 of the Constitution. Full stop. After the statutory rules were notified on 11 July 1961, the High Court of Kerala published the scheme of the examination for recruitment of members of the bar to the Kerala Higher Judicial Service on 13 December 2012. Full stop. The scheme so notified specifically provides that there shall be no cutoff marks for the viva voce. Full stop. The notification, which was issued by the High Court on 30 September 2015, for the conduct of the ensuing examination, provided that the mode of selection would consist of 2 written papers, each carrying 150 marks, and that candidates from the general and OBC category who secured a minimum of 50% marks, into brackets, relaxed to 40% for SC/ST candidates, bracket, would qualify for the viva voce. Full stop. The notification spells out that the aggregate of marks in the written examination and the viva voce would form the basis of drawing up the merit list. Full stop. In the above backdrop, it is evident that when the process began, the process of selection commenced, all candidates were clearly put on notice of the fact that the merit list would be drawn up on the basis of the aggregate marks obtained in the written examination and viva voce, semicolon, that candidates with the prescribed minimum, candidates whose marks were at least at the prescribed minimum in the written examination would qualify for the viva voce. And bracket 3, there was no cutoff applicable in respect to the marks to be obtained in the viva voce while drawing up the merit list in the aggregate. Full stop. The decision of the High Court to prescribe a cutoff in the viva voce was taken by the Administrative Committee on 27 February 2017 after the viva voce was conducted between 16 and 24 January 2017. Let's stop. The process which has been adopted by the High Court suffers from an element of being, suffers from several infirmities. Let's stop. Firstly, the decision of the High Court was contrary to the provisions of Rule 2C(3), which stipulates that the merit list would be drawn up on the basis of the marks obtained in the aggregate in the written examination and the viva voce. Semicolon. Secondly, the scheme which was notified by the High Court on 13 December 2012 clearly specified that there would be no marks, that there would be no cutoff marks in respect of the viva voce. Thirdly, the notification of the High Court dated 30 September 2015 clarified that the process of shortlisting which could be carried out would be only on the basis of the length of service of the members of the bar, should the number of candidates be unduly large. And fourthly, the decision to prescribe a cutoff for the viva voce, the decision to prescribe cutoff marks for the viva voce was taken much after the viva voce tests were conducted in the month of January 2017. Let's stop. For the above reasons, we have come to the conclusion the broader constitutional issue which has been referred in Tej Prakash Pathak would not merit decision on the facts of the present case. Let's stop. Clearly, the view which was taken by the High Court, the decision which was taken by the High Court was ultra vires rules 2(c)(3) as it stands. Let's stop. As a matter of fact, during the course of the hearing, we have been apprised of the fact that the rules have been subsequently amended in 2017 so as to prescribe a cutoff of 35% marks in the viva voce, which, however, was not the prevalent legal position when the present process of selection was initiated on 30 September 2015. Let's stop. Undoubtedly, the High Court may have been, the Administrative Committee of the High Court decided to impose a cutoff for the viva voce examination, actually the reason of ensuring that candidates with the requisite personality assume judicial office. Let's stop. However laudable that approach of the Administrative Committee may have been, such a change was required to be brought in by a substantive amendment to the rules, which came in much later, as noticed above. Let's stop. The High Court was, this is not a case where the rules or the scheme of the High Court was silent. Full stop. It is a well-settled principle of law that where the statutory rules are silent, they can be supplemented in a manner consistent with the object and spirit of the rules by an administrative order. Full stop. In the present case, the statutory rules expressly provided that the select list would be drawn up on the basis of the aggregate of marks obtained in the written examination and the viva voce. Full stop. This was further elaborated in the scheme of 2012, which prescribed that there would be no cutoff marks for the viva voce. It's also reflected in the note. Full stop. This position is also reflected in the notification of the High Court dated 30 September 2015. In this backdrop, we have come to the conclusion that the decision of the High Court suffered from It's being ultra vires, the rules which were framed under Article 233 and 309, besides being manifestly arbitrary. Full stop. Having said this, the question which now arises before the court is regard to the relief which can be granted to the petitioners. Full stop. The final list of successful candidates was issued on 6 March 2017. Full stop. The candidates who have been selected would have now been working as district judges for a little over, for about 6 years. Full stop. In the meantime, all the petitioners who are before the court have not functioned in judicial office. Full stop. At this lapse of time, it may be difficult to direct either the unseating of the candidates who have performed their duties. Full stop. Unseating them at this stage would be contrary to public interest, since they had gained experience as judicial officers in the meantime. Full stop. While the grievance of the petitioners is that if the aggregate of marks in the written examination and viva voce were taken into account, they would rank higher than 3 candidates who are respondents to these proceedings. Equally, it cannot be lost sight. We cannot lose sight of the fact that all the selected candidates are otherwise qualified for judicial office and have been working over a length of time. Full stop. Unseating them would, besides being harsh, result in a situation where the higher judiciary will lose the services of duly qualified candidates who have gained experience over the last 6 years. For these reasons, we have come to the conclusion that it would not be possible to direct the induction of the petitioners into the higher judicial service at the present stage. Full stop. Many of the petitioners would have since joined the bar and would be in active practice. Full stop. It needs to be clarified that their having failed to gain selection to the higher judicial service in the process which was initiated on 30 September 2015 is not a reflection either on their merits or ability, and shall not come in the way of their being considered for any other office, judicial or otherwise, in the future. Full stop. Subject to the full stop. In the view which we have taken in the above terms, we have not considered it necessary to answer the broader question of constitutional, the broader question which has been referred to the Constitution bench. Full stop. The question is kept open to the Constitution bench. Full stop. The petition. Besides, the question has been squarely raised in certain other cases which form a part of the present batch of cases in which arguments are being heard by the Constitution bench. Full stop. The petitions are accordingly disposed of in the above terms.
Thank you. Let's say one small correction, my lord.
Yes.
Decision of the High Court on the administrative side, my lord. So Lordship has said that decision of the High Court.
On the administrative side, I'll correct the answer. So these 5 matters are over right now. 4 matters: 1.5, 0.6, 0.7, and 0.30. 4 matters. Now we take up Rajasthan, right?
Keep it.
Oh my God!
Lordship, Lordship,
Okay, वो reference भी हो गया.
Lordship, may I Lordship, may I request, Lordship, that I may be taken in the last, as I had requested that these are the clerical staff, it is different from others, Lordship.
Now, this is Tej Prakash Pathak, no? That's the lead matter.
That's the lead matter, right?
Lordship.
So
This
what
is
we could do now is, we will take up, we had said that we will take up Rajasthan. You don't want to take up, we'll start with Rajasthan. This is a lead matter.
Lordship, I can start, but Lordship, what is it that it is different? It is different from others. So I may be in the last and then I can point out few things which are different
Does
from them. And
Mr.
it would be
Agarwal, does the
easier.
question arise here? Straight away.
It's straight away, right?
So that's the reference order.
Yes, it's a main reference order.
Main reference order, so Lordship, what I am saying that. Lordship, in the last Lordship.
Which one should we take up? Who's now ready to the hill? Tell us. Mr. Mukherjee, where are you? You are for the petitioners in Manipur.
I'm
And-
here, Manipur.
And you are in Manipur.
It arises in your case also, or are you saying that it won't arise?
No, it's completely
Yeah,
different.
you are contesting that. So Manipur, you are very-
It's completely
Yeah,
different.
arise नहीं होगा.
That is Salam Samarjit Singh versus High Court of Manipur,
Only one
501.4.
Refer to the PDF file, Manas, which will make it.
Yes, that will be much better.
I've learned it the hard way, Manas, but I'm learning.
It's so nice. See, it's so good that everybody is also on the same. And happy the registry is now circulating these files to all the lawyers. And that's very important.
You want us to take the paper book?
We do.
The PDF paper book, Manas, may I,
501.
straight take your lordships to the written submissions which we have filed, that your lordship will find at page, PDF page 460. Sorry, 480, I'm so sorry, 480.
460 is nice.
Just 1 second.
480. Like I'm still learning.
अच्छा किया मैंने कि हाई कोर्ट को नहीं बताया कि आप भी जीरो से नहीं है 5 सुप्रीम कोर्ट के मोटे मोटे जज बैठे हैं वहां पर ये फाइल्ड
इसके पास है सिमिलर
Page 480, Manas.
80.
Yes.
List of dates.
List of dates are broadly large hinges on it.
So we'll quickly run through the list of dates. Good always to.
That'll be easier for us.
That's the table, right? Brief facts and chronology or
After
480?
that, the list of dates will start, Manas, with the date and pages. That
480 you said.
480 and 482.
This one.
It starts at 482 PDF.
The 2005 lordships will find are the recruitment rules under 234-309. And this was after the All India judges case, based on the Justice Shetty recommendations. Rule 7 is what is relevant for us, Mala, the relevant provisions.
Now we are concerned with Rule 7.
But no cutoff. Yes, Mala. So if we kindly see the relevant provisions, Rule 7, method of recruitment, qualification, reservation, so and so. Then, Mala, Schedule B to the MGS schools, competitive examination, limited departmental examination, written examination, 3 papers of 100 marks each. Interview, viva voce, 50 marks. There's no cutoff.
So papers now we must have. Proposing that, now whoever has papers should be directed to make a contribution to the Supreme Court Bar Association Welfare Fund.
We're seeing papers on the tables.
I was just pleading with the Chief Justice for an exemption for the judges,
It was rejected.
Rejected.
It was rejected.
In fact, I make it a point not to take any paperbacks from stores, man. I tell them the next generation will not get paper. The young kids who man the stores, I make it a point not to take any paperbacks or even receipts. I said, please put it on WhatsApp and send the bill to me. If necessary, I'll download it.
All of you have all these papers. What are you doing with papers?
No, this is because we got the PDF only yesterday, Manoj. I got the PDF only yesterday, so I converted it fast.
Yes. We've seen it.
Largely,
been on iPad. I've seen it.
we have decided code 1 to 5 will have the iPad.
No, but seriously, because we must now move to this.
Once you completely shift, you'll know
Yes,
how easy and how advantageous it
They are
is.
very adept at it. They do it very fast. We are still learning. Bhati keeps on telling, when I see her, I hide my papers. She says, where is the iPad? She scolds me. So I told her I'm still learning.
It's always a process.
Yes.
All right, Rule 7.
Yes, Rule 7. Now, also, can you see clause 1 a bit
But
below
hats
that?
off to my brothers. I mean, everybody has really been so cooperative. Everybody is sort of very eagerly doing it. And for us, it's a new normal, actually.
It's a matter of getting used to it. Delhi High Court, I think almost all judges are trained.
Yes.
Yes, Manoj. So Schedule B says, Manoj, Lord will kindly have clause 1. Competitive examination, limited departmental examination, written examination, 3 papers, 100 marks each. Interview of viva, 50 marks, no cutoff. The cutoff comes in the general instructions. All candidates who obtain 60% or more marks or corresponding grade in the written examination shall be eligible for viva voce examination, provided that the SC/ST candidate, I am one of those, who obtain 50% or more marks or corresponding grade in the written examination shall be eligible for viva voce examination. So, records will show I got 50% plus. I was the only candidate who was eligible in the examination. 17 candidates took part in this examination held in 2013. The advertisement, Losh will find there are different grades. We are not concerned with the grades here.
All right.
Losh will kindly come to page running PDF page 483. I need to show one clause in the first block.
That clause 2 is important. Selection of candidates shall be made on the basis of the cumulative grade value obtained in the written and viva.
Absolutely. And then, my lords, will kindly see the last clause 3.
I'm sorry, my lord, I didn't want to interrupt. Only one thing, my lord. Here are the rules. My lords have read mode of evaluation of performance and grading written and viva shall be as follow. 70 so and so, below 40% have failed.
No, that's not.
Just a minute, 483.
Fail, it's only a grade. No, please, let me complete. You will have your chance. But this is difficult. Fail, it's a wrong interpretation. This is what High Court should not do this. He's appearing for the High Court.
Well,
there's nothing known as fail.
I'm appearing for the High Court. I'm so sorry. I'm aware that I'm making
So,
submission on
there's nothing known as fail. It's only a grading given here. Where does the grading say it is fail? Lordship, can you see the grading? The percentages have not yet come to the grading. I'm still in page 482.
But the grade value is 0 basically. Yes. For below 40%, you get 0.
Whatever it is. Now, Lordship, can we see the first block relevant provisions, clause 3. Clause 3.3. So 2 says selection after selection of candidates or based on the cumulative, which your Lordship just read.
Clause 3.3 is all necessary steps.
Yes. This is what the High Court is relying on.
Yes.
So all necessary steps not provided for in these rules, Lordship will note the word rules, for recruitment under these rules shall be decided by the recruiting authority. So all necessary steps, those are administrative steps.
Now these rules which have been framed by the Manipur Judicial Circle, the 2005 rules are under Article 233 or?
234 309.
309.
Then the grading is given at the next block at page 483.
Right.
So 70% grade O, A plus, A, B plus, B, C plus, C, F. So F is where you get below 40% is 0. The grade value is 0. So you don't get a step up because in any case 60 and 50% is a cutoff for the written examination. But you saw that in the beginning. 60 for general candidates, 50 for SC. Yes. I'm one SC candidate.
But it said written examination and Viva VOC exam over here.
Yes. So the cumulative grade. But for Viva, I showed 50 marks, but no cutoff. That's an accepted position. At that date, there was no cutoff. Then comes the advertisement of 15/5/2013. So there was applicant direct recruitment to one vacant unreserved post of district judge entry level. Then while 17/10/2013, the written examinations were held. 17 appeared at the examination. The list is at page 122 PDF. And there was a notification saying that none had qualified. Lots will note this. 17/10/2013, it said none had qualified. I did a RTI and on 29/1/2014 found that I had 52.8% marks. Therefore, I stood qualified. Then I asked for a review.
When were the results declared?
Yes, Malas, the results are 17/10/2013.
That's the date of the result.
Yes, that's at page 122.
Okay, I get it.
So 4/2/2014, I asked for a review of this rejection of even my candidature. Then the High Court 7/2/2014 issues a corrigendum saying that I had in fact qualified. That I was the sole successful candidate. Then, my lords, before the Viva could be held, without any intimation to me, a full court resolution was passed on the 12th of January 2015. And this, my lords, makes a little interesting reading. If I may read this document once, my lords. It was specific to me. And that PDF, Lordship will find at page 147. This document is important in the full court resolution at page 147 PDF. There's the minutes of the full court held on 12/1/2015 at page 147 PDF. And this full court resolution is specific by taking my name. It's almost the same as the P. Venugopal dietary aims, whether your lordship struck down that act saying that you cannot have a single specific instance of one person. So that becomes a malice in law. Here, my lords, with respect to the High Court, Can you see the resolution? Considering all the relevant provisions of Manipur judicial. So, Malad, this is, let's have a look at the resolution at page 147.
2015.
Yes. 12/1/2015, considering all the relevant provisions of Manipur Judicial Service, Shri Salam Samarjit Singh, who secured more than minimum qualifying marks in the written examination, is qualified for interview and he shall be called for facing interview. Now, qualifying marks for interview, Viva Bose, a question as to what percentage would be the minimum qualifying marks of passing interview, Viva Bose is discussed. The following provisions of sub-rule 3 of Schedule B of Manipur Judicial Services rules are taken into consideration, and they rely on that clause 3 which I read, Manas. All necessary steps not provided for in these rules for recruitment under this rule shall be decided by the recruitment authority. The mode of evaluating the performance of grading in the written and Viva Voce shall be as specified below. Evaluating performance in competitive examination of judicial selection, or should we skip that? Then, Manas, below the table, the full court, after considering the power conferred on the recruitment authority in the above states, rules and percentage of marks with grade value given above, resolve that no one shall be declared passed and selected for appointment unless he secures minimum 40% from the interview by Babose. So this is almost like an executive instruction. They introduced this by using the so-called enabling power, which in my respectful submission is not a power which really amends the rule, and says that 40% now. So Rajiv has seen that clause 2 said cumulative of Viva. It does not prescribe any cutoff marks. So this happens. Then the Viva happens minus 12/2/2015, 1 year after my selection was held to be valid in the first stage, which is 7/2/2014. I showed the letter. The corrigendum came that I am the sole candidate. They waited for 1 year, held the full court, and designedly said that there will be a cutoff of 40%. And the Viva was held, and I apparently got 18.8% marks out of 50, and therefore that cutoff of 40% is not met by me by 1.2%.
You got how much you said?
18.8 marks, Manas, out of 50. So the cutoff would be 20, because 40% according to the High Court.
Unlike the previous case which we decided Kerala,
yes,
the Viva cutoff was decided here before the Viva was actually held.
Yes. But there was a 1 year lag time.
Right.
I was not informed about this. I had no knowledge of this cutoff in any case. Had I knowledge, I do not know what I could have done. But I could have still challenged it at that stage.
It was not as if the Viva was held and thereafter they decided to.
But the selection process was on. So therefore
that issue of midstream change in rules applies here.
And then this lag time of 1 year also, they kept it pending.
Initially, they said none had qualified.
Yes.
So they gave a corrigendum to that. So this process also, otherwise you are not even in the fray.
Initially.
Now, because of the corrigendum, you come in the
I come in the fray. As a lower
they allow you to participate in the Viva. But in the Viva, you don't meet the benchmark.
According to the benchmark. And the rules now stand amended in 2016. They actually formally amend the rules in 2016. Wait, Baba, if you keep on saying. Nine 2016 is a formal amendment to the rule, man. Judgments all. Yes, sir. So Lordship will find that amended rule at page 285 PDF, 9/3/2016. So there's almost
285.
285, 1 year, 1 month after the full court resolution. In between, the viva takes place. I was told of the full court resolution after the viva is over, when I was declared to be not successful. So the cumulative would be A plus B, written examination plus viva. At the time of giving the exam, no cutoff marks for viva. And the rules come in 9th of March 2016, formally introducing this cutoff marks, my lords, at the end of, at page 287, general instructions.
Thereafter, this is all
Thereafter, so there was a.
So they differed, both of them differed.
They differed.
Then. Yeah, yeah. And now both of them differed.
Yes.
And first of all, when you filed a writ petition here, did you get an interim order?
No, we got an interim order. The next election, which was scheduled for 17.
Keep them post aside.
Yes, they said that.
We saw that. So there was an interim order which says that direction to keep them post aside.
Slightly peculiar interim order, but we got an interim order.
What is the date of that interim order?
It says 9/5/2017, 4545. So it says that if the selection process continues, the last selected candidate shall be intimated that his/her selection is subject to the final result of this writ petition. The selection finally happened, I believe, in 2019 and 2021, in 2021. So 17 was his interim order.
2017.
17. And the selections happened in 2021. So it says that the last selected candidate shall be intimated that his/her selection is subject to the final result of this writ petition. So there are 4 selected.
but they've deferred. They deferred on October 16,
Yes.
right?
Yes.
And then the interim order came to be passed in May 17.
Now, just because of the difference of opinion, may I read that judgment?
October 16. Okay, at the end. October.
First one. Salam. Yeah, China. So, well, this the difference of opinion happened on 7th of October 2016. Where these three issues actually arose for consideration. That's why I said the questions in my case will be slightly. May I hand over these three questions, which according to me arose?
The only difference between yours and the previous one is that after the written test was over in October 2013,
yes,
filed a writ petition and all that.
Yes.
Full court decision was in 12th of January 2015.
That's right.
Which interpreted the rules and said that the rule enables the authority, the court to adopt procedure.
Whatever procedure, yes.
So you say that that rule won't apply, it's procedural rule, but then they referred to that rule and imposed this 40%.
That's right.
And now that is January 2015 full court.
Yes.
And they informed you on 29th January. We just saw that. 29th January, they informed you.
That's right.
Within about few days thereafter.
No, they did not inform.
And after
Yes,
that.
no, I'm sorry, man. With respect. They informed for the Viva Voce. I was not informed the full court resolution ever.
About the Viva Voce, that there will be a Viva Voce.
That's right.
That's all, is it? They didn't tell you about this 40%.
Nothing. The full court was, I came to know only through RTA.
Okay, anyway, the Viva Voce was conducted thereafter in February 2015.
12/2/2015.
Right.
Yes.
Then finally, then the decision was on 16 February 15 when they said that you are not eligible for the reason that you got only 18 marks out of 40 marks.
18.8 out of 50.
18.5 out of 40. Which you challenged here again directly.
I challenged that.
2015, Mr. Mukherjee, then.
Yeah.
Same.
It was filed in 2015. It was filed in 2015.
You have to take a call.
What does it say for the Viva? That all candidates who have obtained 60% or more marks, the written exam, shall be eligible for Viva.
Yes.
And selection of candidates shall be made on the basis of cumulative grade value obtained in the written and Viva Voce.
Viva 50 marks. There was no cutoff. So it is acknowledged that the cutoff was introduced only by the full court decision. That accepted position is, till that full court decision, there was no cutoff marks for Viva. A cumulative of that exam where 60, 50 are the two stages for two eligible sets of candidates, plus the Viva. So if there are competing interests, they will obviously take the topmost. Incidentally, I was the only candidate. So whether I should get a march-in or not, that's another aspect of the matter. My learned friend will argue no indisputable right that I should get appointed. That's another aspect of the matter. We are only in the procedure today. The procedure as it existed did not broach of any Viva cutoff marks. That's the submission.
So why are you saying that the reference won't apply to you?
The reference, Manos, I'll tell you, Lordship, because the difference of opinion of the two learned judges here was on three major issues.
Was on the interpretation of the section,
on the interpretation
of the rule.
Of the rules.
So if we accept one of the views that this provision is only procedural and not intended to empower amendment or addition of a cutoff,
That this is
then in which case, that's the point of distinction.
That's the point of distinction. The point is, and there are actually, may I just show the three questions which we had raised before the division bench? And the two learned judges differed on all three. Justice Bhanumati held all three against us. Justice Shivkiti, all three in our favor.
What are the
He also goes to say there's malice in law at para 45 of the judgment. Take it, take it.
Years, what can we do for your client now?
I was telling you, I was going to answer the question that this was wrong, but I don't know, because today apparently I believe.
What's your client doing?
The lawyer practicing.
How old is he now?
He should be 46. Because 2013 was the person 35 plus.
Now he can aspire to become a High Court judge.
Is it really? I mean,
Easier
very
said
serious,
than done.
is he really interested? Because
Right, that's what I
joining
said,
now, man,
At 46, we'll have no career ahead in
no
the
career at all.
Why I thought this, with respect to the smaller states, my lord, the progression is faster than in these larger states.
No, not always. I'll tell you why. The vacancies are fewer also.
This was only one single advertisement, single post advertisement.
Single post, that
So
point.
therefore vacancies, as the Chief Justice pointed out.
Later on, it happened four came about.
So,
There are always,
see, my brother is telling that the
The
exam
advertisement was cancelled and thereafter the vacancy was clubbed with the subsequent advertisement.
Later on, 2019, 2021.
So therefore,
That is where I got this interim order in my favor.
So therefore, this exam, this advertisement of 2013 did not culminate. So it got cancelled in between.
No, 2013 never got cancelled. The subsequent examination got cancelled.
Subsequent wala.
It was not 2013. 13 went through his usual course of being eligible,
got
knocking me out, and then my RTI.
Now, after 10 years.
We kept on trying to get the matter listed, and all of that. The only thing I can lament, my lord.
The great biggest concern is Mr. Mukherjee, the time that.
It was 21. I'm sorry, ma'am.
So, just like this, when we've understood that we have kept the matter pending here, but then what do we do at this stage?
In fact, one of the difference of opinion with my how I have understood the two judgments. The Tej Prakash was just touched upon, noticed by Justice Bhanumati to say a reference is pending. Justice Shivkiti Singh says it does not matter. That reference does not affect the facts of these cases. So therefore, those three issues which were raised and answered are summarized here. The suffering continued with the full court resolution, knocking me out at the first stage, not including my name. Then the Supreme Court having a difference of opinion. And I'm.
What is to be done according to you here?
Just one interjection.
Yes.
Very.
Here, Mr. Rana Mukherjee says, Mr. Mukherjee says that, look, First, you told him that he's not qualified.
He is not qualified, my lord. I will show to your lordship. My
Then
learned
he
friend
gives
says
an
in the law.
RTI. After the RTI, you tell him you have qualified.
No, not after.
Then you call a full court and change the resolution.
No, that's what I'm
And
saying.
finally, you tell him that, look,
that's
now
what I
you're not
wanted to show to
qualified.
your lordship, lord.
You don't
In
get
fact,
40%.
my lord, the High Court, my lord, in law, again, appearing for the High Court, my lord, I can justify, my lord. In law, my lord, he is not qualified. The advertisement was for an unreserved post. For unreserved post, minimum qualifying marks to appear in the Viva, my lord, is 60%. He gets 52% in return. Then he made a representation to the High Court.
Where do you get that?
Yes, my lord. Would your lordship see the advertisement? First, my lord. The advertisement is at page 111 of the PDF.
Right. Okay. Do you see the list of dates? Page, what is the page of the advertisement?
No, for first thing, my lord, I'm saying the advertisement, lordship, would see page 111, which is PDF 111. Number of posts advertised is unreserved 1.
Yeah, we got it.
And now the lordship may kindly see the rules. The entire rules are, my lord, at 397.
You just tell us that page where you want us to go. You just tell us that page where that 60 for that mark.
Yes, my lord, 1. My lord, first 111, my lord, 111.
Okay.
That is the advertisement, my lord, which will show 15th May 2013, one vacancy, particulars at the bottom of the page, unreserved 1 vacant post. This is unreserved post. Now, my lord, lordship may kindly see the rules now, which is 397, the entire rules, my lord. My learned friend quoted from some part of it. The rule says, my lord, page 397, it starts at 401. For 25% direct, it should be as per Schedule B.
What is there? It says grade 1.
Yes, my lord. Grade 1, that is, my lord, that is 25% direct recruitment. Page 401 top. Grade 1, that is, my lord, direct recruitment. On the last column, lordship, we get direct recruitment. 25% of the post should be conducted as specified in Schedule B of the rules. My lords have got it. Middle, my lord, third column.
Not exceeding 25% of the posts in the cadre.
Yes.
Maybe filled by direct recruitment.
On the basis of aggregate marks secured in the competitive examination conducted by High Court as specified in Schedule 1 of the rules. Schedule B of the rules. Now, Schedule B, lordship would get it, my lord, at 428.
Not able. Nila,
That 60%. Lord, for direct recruitment, 428, my lords have got it.
401, right?
Yes, 401 first, my lord. Yes, I'm so sorry.
Just read that, not exceeding, आपको मिला?
Yeah. 401 says, my lord.
Not exceeding 25%.
Yes, it's part of Rule 7 column. Not exceeding 25% post in the cadre may be filled by direct recruitment on the basis of the aggregate mark grade secured in the competitive examination conducted by the High Court as specified in Schedule B of the rules.
Changing your mind. So this says this is only the quota for the direct recruitment.
No, yes. Then lordship will go to Schedule B.
As per Schedule B.
Yes. Now lordship may kindly see Schedule B at 428.
Mr. Hansaria, take us to 428 directly.
Yes. Schedule B 4. Then lord, there are 3 papers. Interview 50 marks. At 430, bottom, all candidates who obtain 60% or more marks or corresponding grade value in the written examination shall be eligible for Viva post. Provided it's schedule types who obtain 50%, the corresponding grade will be eligible for Viva post. Look, this will apply for the reserve category. For the general category, seat.
Below general instructions.
This general instructions, my lord, of part of Schedule B.
Provided the schedule caste, schedule tribe candidates who obtain
to get 60%.
50% marks or more.
For SC/ST, it will be, my lord, 50%. But if it is SC/ST reserve seat, my lord, But since the seat was, my lord, a not reserved seat,
It's a general
it was a
category.
general seat,
So the
you have
cutoff is 60%.
60%.
This person has obtained 52%.
52%. He gave a representation. My lord, it was a new high court in 2013 constituted. For the first time recruitment made. They considered all right, there are no available candidates. My lord, in fact, that principle, somebody could have challenged it and saying that his calling of interview is bad. Appearing for the high court, I can't say that decision is wrong.
No, but that, Mr. Hansaria, you may not be correct.
Yes.
A reserved category candidate may also contest for an unreserved seat.
Yes, my lord.
Now, see what it says, provided
yes, my lord,
that scheduled caste, let's see the whole thing. All
Yes, my lord.
candidates who obtain 60% or more marks for corresponding grade in the written examination shall be eligible for viva voce.
Please, your lordships.
Provided that scheduled caste, scheduled tribe candidates
Yes.
who obtain 50% or more marks or corresponding grade in the written examination shall be eligible for the viva voce.
My lord.
Now, this does not say only in respect
Reserve-
of a
My
reserved
lord, I
seat.
understand, my lord. What I'm saying, my lord,
If it's
it
a
is-
scheduled caste candidate,
my lord, it
yes,
is a
It happens
possible.
in every school, college admission, my lord.
No, my lord.
School, college admission happens like that.
Competing for a general.
Yes, that's not for reserve post. For reserve
it's
post,
for
it's
any
different
post.
criteria.
For any post.
Yeah, for any post.
It is the concessional mark is applicable to the candidate, not
to the
relative
post.
My lord, it is post, my lord. That is, my lord.
No,
what?
no, it can't.
Very well.
It's
My lord,
can't
High
be.
High
once
Court having
the-
called him, my lord, I
The
cannot.
High Court says you are eligible to appear
My
for
lord,
the
that's
viva
why he
voce.
made a
How can you
repre-
argue that you are not
Initially,
eligible?
High Court thought it is not. High Court made a representation. Lordship would kindly see thereafter, my lord. After that, in the same page
That means he was
431.
eligible to appear for the viva voce.
I'm so sorry. my lord.
He was eligible to
Very
appear.
well, Lord, that he has been made a pillar. What I'm saying is 431 at the fourth, all necessary steps provided rules under this shall be decided by the recruitment committee. Thereafter, my lord, what is important is this: the mode of evaluation, page 431. After that quotation, with all necessary steps not provided in these rules. So, my lord, it is silent. It is does not similarly required. For the recruitment, it shall be decided by, then thereafter, my lord, the mode of evaluating the performance of the grading in the written and viva shall be specified below. So, my lord, both has been given. Grading and, my lord, for both written and viva is below. Now, below is, my lord, the chart is there at page 432. So this chart is applicable for both written and viva. Now, in says percentage of marks, O is outstanding. Well, this gradation, my lord, is not only in these high court rules. For example, my lord, I have been checking on the line. National Institute of Technology. It also, it's not here, it does not. So O is outstanding. A plus A, B plus B, C plus C, and F. F is in fail. It is written, my lord, in others.
That case where after the subsequent resolution,
Yes.
you prescribed a cutoff for viva voce. And in that viva voce, he according to you obtained 18 marks.
18.8.
18.8 as against the 40
My
required.
lord.
That's the reason why you.
My lord, what I am saying, my lord, this
Therefore, all other points that
No,
you
no.
are making.
Full
which
court
have
has
no relevance
interpreted these rules, my lord, and made it clarified. I'm saying it is not introduced for the first time. It is a clarification in nature. If a lordship see the full court resolution quotes these rules, my lord, and also, my lord, the earlier part, and say, my lord, we will go by 40%. And can I not, my lord, an appointing authority?
Where is the requirement of 40% in the rules?
No, my lord, that's what I'm saying, my lord. Below 40%,
Where?
is this chart, page 432, which is my lord, necessary for evaluation for both written and viva.
Read that, please.
My lord, a 431 bottom, it says mode of evaluation of performance of candidates for both in written and viva shall be as specified below. My lords have got it, my lord. 431.
Okay, but this is the
Mode of evaluating.
Now go ahead.
I'm so sorry.
Go ahead. So,
Yes, evaluating performance in the competitive exams for judicial selection. System operates as follows: all question paper carry numerical, etc., etc. Then the tabular will then convert the numerical marks into grades. 7-point grade corresponding as value follows. Then, my lord, these grades are given 70%, etc. You get so and so. My lord, if you got below 40%, it is F.
But 40% is not confined to viva voce.
My lord, it is written. My lord, it is the same standard. My lord, what the rule says, it is the same standard for written and viva. That is 431. That's why I was reading 431. The mode of evaluating the performance.
It's merely saying because there was no prescription of having viva voce to be evaluated separately.
That's
Because
right.
there was no cutoff at that point of time. These rules relate to that period. So they say that anybody who obtains
Less than 40.
outstanding 70%, he will
Yes.
get grade 7.
Yes.
And anybody in a totality of the marks gets below 40%, he will be a F candidate and the grade is 0.
And F
But to say, what has this got to do with your?
No, what I'm saying, my lord, before that, if I'm sorry, I've not made clear. 431 says this tabulation, my lord, relate the mode of evaluating performance of grading in the written and viva
Yes, it's N by Y. It has
shall
to
be as specified below. So, my lord, this tabulation or mode of evaluation of gradation system.
Is it your argument saying that you first of all take the written examination and then see whether 40% is prescribed, whether he is falling under this category, then he will be eligible. Then also have a look at the Viva VOC also.
Yes.
And then the 40% has to be seen even for
both.
Viva VOC separately.
Also, yes. And that is how, my lord, the full court understood.
That was the way, that's the way you should read the rule. Then your
No, my lord, that's why
court was unnecessary.
then, my lord, we changed the rule because this proceedings.
Why did you call for a full court then?
No, that's what let me explain that, my lord. Then, my lord, in full court took the decision, my lord. It is more of a clarificatory nature. In any event, before this, my lord, the interview was held by the full court.
And this scheme which you are showing commencing at Schedule B,
yes,
existed in the rules from the very beginning.
I'm so sorry, my lord. Yes, it's 2005 rules, my lord. The new High Court comes in 2013, Manipur High Court. And 2015, before the interview.
And you know, one more thing.
Yes.
This conversion, the rules prescribe, see, it's for each question.
My lord.
It's not for the overall exam. See how it is. Let's go back to internal page 39, that is 431. The mode of evaluating the performance of grading in the written and Viva VOC examination shall be as specified below.
Yes, my lord.
Now, the system operates as follows.
Yes.
The questions in the question paper may carry numerical marks for each question.
My lord.
Okay. Now, the examiner may assign numerical marks for each sub-question which may be totaled up and shown against each full question in numbers. Now, the tabulator will then convert the numerical marks into grades in a 7-point scale with corresponding grade values as follows, which you showed us.
Please, Lord.
After converting the numerical marks of each question into the appropriate grade, according to the formula given in first column above, the tabulator will reconvert to the grades obtained for each question to the grade value according to the value given in the third column above.
My lord.
What is now obtained in the relevant grade value for each answer in the question paper obtained by the candidate in a 7-point scale. The next tabulator's next task is to add up those grade values and divide the sum total by number of questions in the answer book, including the question unanswered by the candidate.
My lord.
Applying it to Viva VOC is a far cry, Mr.
Not on this analogy, at least.
And it looks about, it refers to the answer book.
It goes on till clause 10. Then the Viva comes in, cumulative score. I don't know what Latif is trying to argue.
The similar vigorous and objective grade value exercise for the Viva VOC examination as well.
Yes. After the evaluation is done, after the question papers are evaluated and grades, because I would not get a look in if I had not got 52%. So these grades enable a candidate to get in a step in for the next stage. That's the Viva. So 60, 50. I get the threshold of 50 plus. I get a call in for the Viva. The Viva comes in at the clause 9. The final selection list will be ready by combining
two submissions, my lord.
And the Viva will say clause 9.
First is, my lord. The high.
Say schedule to the rule, I say. Competitive examination schedule B, it's a part of the rule. And then look at the way it is composed. It is putting questions and it is answering questions.
Yes.
See, look at this. Para 6. What happens if there are several successful candidates obtained the same grade?
These were Assam rules, my lord. These were lifted bodily from the Manipur. It is made for all the states, my lord. I've checked up the Assam rules are all identical, my lord.
And 9 is cumulative value of both.
My lord, what I'm saying is, my lord, apart from this, my lord, before he is, my lord, interviewed, the full court, which is the 3 honorable judges, my lord, who were there, who found that he was not, then he was called. Before this selection, the
follow
is that all this happened in 2013.
15.
15.
15.
13 advertisement, my lord.
13 advertisement.
16.
Right.
Let us take it
Now
to
we are
16.
10 years down the line, or at the least 8 years down the line.
No, I am told.
We'll
I'm
leave
told
it at that,
we-
Mr. Mukherjee.
No, may I say it first? I believe.
We can't spend more time in a
No, I understand.
constitutional bench in a matter like this.
No, I'll tell you.
Let's close it by saying that, the selection relates to the year 2013. Selection process took place in 2015. At this stage, it is not possible to get you
So
appointed
the
as a.
question of the full, this reference would remain, my reference. No, I'm not talking of Tej Prakash. The reference in this, the
It's
division
not
of
necessary
opinion.
to answer the reference in this case.
Reference will answer in that matter.
No, that my submission is Tej Prakash is not attracted to my case. That's what I said at the beginning. Because of the difference of opinion, the issue will still be at large. Because if I follow Naushad, my lords,
On the facts, we don't have to answer this now.
Like at the very beginning, you have distanced yourself from the Tej Prakash. case.
yes, because
Distance, you said that I'll make submissions at the.
that's so that's what I was trying to submit. That
But on this.
my issues are different here.
Because it's for resolution of.
I believe 2 posts are filled up by retired judges. May I take the interim order to my advantage? I'll just pick two submissions. Just one minute, sir. Two
It is not a case, my lord, where anybody who is got lesser marks than him has been appointed. And at page 431, my lord, I'm so sorry.
Mr. Mukherjee, also there's the issue of the reference doesn't arise in this case.
The Tej Prakash issue does not. The reference in my case arises. The difference of opinion.
That is
Ah,
because
the
of
but
difference
that
of
has to go
opinion.
before 3.
Yeah, that should go. Now just 2 submissions, because on this, what your lordship said, I believe because of this interim order, the last 2 posts are filled up by retired judges and they are appointed 2 years in rotation. I would still have 14 years of service, my lords. He's willing to, my instructions are he's willing to join. Manipur, lordship sees 2 exams are cancelled, you don't get candidates. Here's a candidate who qualified. Why should he be knocked out like this? The High Court has been obstructing, even here, he's obstructing me, even from arguing.
Oh.
So I don't know why should the High Court start.
I'll sit down. I will stand up when my
It's not how the 14 hours don't work.
Mukherjee, what we were wondering is that, really speaking, there's a difference of opinion between 2 judges
On rule.
on the application of the rule.
On that, yes,
Right? Now, in that case, it has to be resolved by a bench of 3.
Yes.
If the issue which has been referred to the constitution bench does not squarely arise over here, why should we entertain it? We'll send it back to a bench of 3 judges.
And also equities can be looked into by that bench and then say because one.
Could I make a soft request, Manas?
Yes.
Subject to your lordship convenience. Could this be listed as fast as
Yes,
possible, Manas? Because
We can.
every day I'm
We
losing
can,
time.
we can.
Every day I'm losing time.
Just
The proceedings have been on on 7 October 2016. The bench of two learned judges, which was considering Writ Petition Civil 294 of 2015, deferred. Full stop. Now, when was it tagged?
Then it just said August 2017, my lord.
Right, I got it. Thereafter, on 10 August 2017, a three-judge bench passed the following order. वो copy कर लीजिए. So, from the above narration, it emerges that the direction to tag the matter with the reference to the Constitution bench in Tej Prakash Pathak versus Rajasthan High Court 2013 for SEC 540 was on the submission of learned counsel appearing on behalf of the contesting parties that a similar question of law had been referred. But during the course of the hearing, Mr. Rana Mukherjee, learned senior counsel appearing on behalf of the petitioners, submits that
these questions arise for. Would that be at variance with the Tej Prakash reference? So it will be easier for me to argue there. But we can have, I'm sorry. Fine. I've given you a copy. How many have it here?
No, there are other questions.
Mr. Rana Mukherjee, learned senior counsel,
No, there are other questions.
appearing on behalf of the petitioner, submits that submits that the following three questions would be sought to be urged in the course of the decision of the reference to the three judges, to the three-judge bench, colon, ये 1, 2, and 3 copy कर लीजिए. Just a procedural. Yes. Procedural fairness and fairness.
Look, there are other questions which also arise. Otherwise, Lord, I will be foreclosed from arguing.
Mr. Vijay Hansaria, learned senior counsel appearing on behalf of the respondent, states that he would wish to raise certain other questions.
Lord, which I have raised, Lord, in my submission.
Yes, we are keeping it open. Since in view of the statement which has been, since in view of the above position, it emerges during the course of the hearing that a reference to the Constitution bench along the lines as in Tej Prakash Pathak is unnecessary. But stop. The difference of opinion between the two-judge bench between the two judges would have to be resolved by a three-judge bench. Stop. We accordingly direct the registry to add the present case to the list of three-judge bench matters and to seek an assignment to an appropriate bench at an early date.
Because there's an earlier order of
at an early date, I'll take it. I have to assign that. I'll take the registrar.
I understand, madam. The pressures are.
No, I'll immediately do that.
I'm deeply obliged.
Yes. Yeah, we'll have to decide that Tej Prakash in that matter.
I'm deeply
easier with